Well, good morning to everyone. It's now 9:07 on August the 2nd. I'd like to call to order this meeting of the Tennessee Board of Examiners for Land Surveyors. The first order of agenda will be, our first item will be to adopt our agenda. I'd like to ask if anyone has any changes or additions to the agenda as it is written. Anything, sir? I would like to add one thing, if I may, at the board's pleasure. I would like to add an item called legislative proposals, of which we will see in the executive director's report. The reason I'd like to add that item is so that when we discuss it, we would be able to take some type of action as a board on any individual item that we would so choose to speak to, and be able to give direction to our executive director on what the board's pleasure is. So if no one has any problem with that, we will need a motion to accept that as an addition to the agenda.
So moved.
Do we have a second? All those in favor?
Aye.
Okay, so we will add that. Okay, the next item on the agenda will be election of officers. We elect two officers annually, that being the chairman and the vice chairman. So at this time, I'll open the floor for nominations for the chairman.
Mr. Chairman, I nominate Tim Blankenfeld as chairman one more time.
I second.
Thank you very much. As there's no other nominations, I'll close them and we'll call for a vote.
All right.
Okay.
I approve.
Aye. Okay. I'll say thank you very much in your confidence, and I hope that it will be justified. Now I'll open the floor for nominations for vice chairman.
I nominate Galen Northcutt.
And I'll second that. So we'll close the nominations. And we'll now vote. Those in favor? Aye. Congratulations, Mr. Northcutt. Hope I don't get sick.
I hope you don't either.
All right. Well, thank you all very much, and I know that Galen and I will certainly try to do our very best to maintain your confidence and make sure that the board runs in the manner it should. The next item on the agenda will be review of minutes of our previous meeting.
Where is which half one of this thing?
You got another screen there, no?
I may have to get you another one. I'm going to rather take
Please do it.
this was like clear out.
You use this one. I've got the paper.
Well, I've got the paper there. We can continue on.
Okay.
Thank you.
Okay, well, hopefully everyone has had an opportunity to read the minutes from our last meeting. Does anyone have any changes or additions to the minutes as they are currently written?
No, I don't. I move that we accept the minutes.
Okay, we have a motion to accept.
I second.
And we have a second. All those in favor?
Aye.
Okay. And it passed. Okay. The next thing that we need to speak to is setting up our schedule for our 2013 meetings. Donna, have you explored the calendar for these meetings?
Let me go with you.
Okay.
I think the October meeting, the April meeting is our exam is
It's early.
like 12th, 13th, or 13th.
Yeah, it's early if I remember right. my daughter took me and God, she said, Daddy, you're going to get this. I said, yes, ma'am.
Which game did you do?
It's a droid razor or something like this.
April 12th and 13th, I mean, April 13th. April 12th and 13th is 2013.
Okay.
And then October 25th and 26th.
4, 12, and 13, and 10, 25, and 26 again?
Yeah, this time it's 26, 27, next year is 25, 26.
26. Is that right?
25, 26. This year's 26.
Yeah, this year's 25, 26, next year's what?
No, this year is 26, 27. Next year is 25, 26.
Oh, okay, that's right, Friday, Saturday, 26, 27, okay.
Yeah.
Because our board meeting's 25, 26.
Right.
Okay, so we need to meet in February, and we need to meet in August to accommodate the application as always.
Right.
So what day do we want to meet in February? We can meet January 31st and February 1st, or February 7th, February 8th, whatever y'all's pleasure is.
It doesn't matter with me.
I mean, it doesn't matter to me either, just whatever y'all's pleasure.
I don't know what the weather will be like, I never know that, but
Do we want to do 7 and
7 and 8.
7 and 8?
Well,
Okay.
7 and 8.
I will do 7 and 8. Okay. For February, let's see what happens here in August.
Are we going to meet in April?
Yes, we'll meet February 7 and 8,
Okay.
and we'll do a motion to this effect,
Oh, okay.
Donna. And April 12 and 13,
Yep.
and then August. Any pleasure on August?
Well, April 12th and 13th, that's Friday and Saturday.
Oh, okay. So it'll be
11
okay,
and
it'll be
12.
11 and 12. Okay, thank you. Okay. Guess it'll be 11 and 12. Okay. Now in August, do we want to do the first week again, 1 and 2, or yeah, 1 and 2?
That'd be 1 and 2 is good as far as I'm concerned.
It's fine, man.
It doesn't matter.
2, you have any?
Fine.
Okay.
That way.
All right, August 1 and 2, and then that means we'll meet October 24 and 25.
Yeah, 24 and 25.
Because 25 is the Friday when the exam starts.
That's right.
And that should help us meet our deadlines for the exam windows for NCWS.
Because when it starts January 14th, 2014.
Yeah. But we'll have now, in 2014, just so we're looking ahead, we'll have a little bit different scenario because our applications situation is going to change a little bit because in the April exam of 2014 will be our first CBT experience. So
Is that date already set? I don't remember whether it was or not, or is it?
I'm
The
pretty
national,
sure.
the PS and TS part would be April 14, would be April 11, 12. And then October would be 24, 25. Because we're still going to be given the PS exam, right?
Yeah, we're still giving the PS exam.
Yeah,
And that may only be for 1 year.
right.
Gail and I'll find that out when we go to St. Louis. So we'll learn that. Okay. So if I am correct, then each of these dates that I'll speak to now are a Thursday and a Friday.
Right.
February 7 and 8, April 11 and 12, August 1 and 2, and October 24 and 25. Okay?
That's what I have.
Okay. If no one has a problem with that, let's go ahead and just take a motion from the board, and we'll accept those, and then that way Donna can publish them in our newsletter and on the website.
So moved.
Okay. We have a second?
Second.
Okay, we have a motion, second. Everybody in favor, say aye.
Aye.
Okay, opposed? Okay, good. All right, now we have a schedule. Okay. I think we're now to the point where we'll see what Mr. Joseph is here. Here for me first. And we're going to pass it to Mr. Herndon and let him lead if that's okay.
Okay, we're going to do the legal report. The reason for litigators here is because the first one on here is the one that's in his lap. I'm just going to read this into the record, and then I'll let Jesse add to it, or you can ask him questions about it. Is that all right? It's kind of had a story history here. As you can see, this is 2007 case, 2007-059911, and that actual text here is written by Jesse. The following case has been in litigation for some time, and after much procedural activity, the legal office feels that the matter has reached a point at which the board may make a dispositive decision. The litigating attorney's synopsis and recommendation is as follows. In a matter involving a boundary dispute, which is in the Chancery Court lawsuit, with his neighbor, the complaining landowner's complaint alleged the respondent made several errors in the respondent's survey of his neighbor's property. The respondent's testimony at trial was found to be unreliable by the Wayne County Chancery Court, and a final order entered in July of 2009. And the court also found that the respondent relied more on the representation, statements, and desires of the neighbor's attorney than on the cause of the neighbor's deed. The respondent had prepared a plat for the neighbor in early 2007 that resulted in this Chancery Court litigation. And the Chancery Court attributed errors in the boundary dispute as a result of the respondent's plat. This complaint was submitted while the Chancery Court suit was pending in the spring of 2007, and the department did not receive the Chancery Court's final order until January of 2010. The consent order was approved by the board in the spring of 2010 against the respondent for a $1,000 civil penalty and a completion of a 2-hour course of ethics. This consent order was not accepted by the respondent. Respondents denied that his testimony was unreliable or that he committed any violations in this matter, though he through his retained counsel. The complaint was submitted for litigation in November of 2010. In the late spring of 2011, the litigation counsel determined that in order to prove our case by a preponderance of evidence, an expert opinion was necessary that respondent had likely violated the standard of care and violated applicable statutes and rules of this board. This determination was based on the following. Number one, litigation counsel has attempted without success to obtain from both attorneys in the Chancery Court suit and from the court reporter a copy of any transcript of the Chancery Court trial in this boundary dispute, to have evidence of exactly what respondent's testimony was, which was found unreliable by the Chancellor. Consent from one of these lawyers is required for a non-party to the Chancery Court case, our office, to order a copy of such a transcript, and such consent was sought but not obtained. Moreover, litigation counsel called the court reporter, who advised that according to her recollection, no transcript was ever ordered by the parties to that Chancery Court litigation. There was no transcript. Number two, entering into evidence a copy of the Chancery Court's final order is not enough to satisfy our burden of proof. Since respondent claims the Chancellor erred and would be allowed to testify to that effect in a state administrative hearing before this board. The Chancellor cannot be compelled to give testimony in any state administrative hearing about his ruling. As the board is aware, contracts for the department to employ complaint reviewers, expert witnesses in this board's cases were not approved until approximately February of this year. We sent this complaint and all supporting documentation, including respondents and the neighbors' surveyors' plats, for an opinion to one of the complaint reviewers in mid-March of this year. We received the reviewer's opinion in early April 2012. We expected the reviewer to cite the specific provisions of the board's standards of practice contained in the appropriate chapter of this board's rules, the one that deals with the substance of the respondent's work product, and the specific provisions of the board's statutes, if he was of the opinion that the respondent's conduct fell below the standard of care. However, we did not receive any of those citations in the review. The reviewer did, however, believe that respondent's actions violated Rule 082004-021, proper conduct of practice, and that the respondent did not at all times recognize the primary obligation to protect the safety, health, and welfare of the public and the performance of the registrant's professional duties. This meaning the respondent did not protect the welfare of the complainant, adjoining landowner, or of an adjoining church center. Second rule, 082004-041, public statements, and that according to the final order of the Chancellor, respondent was not completely objective in all professional reports, statements, or testimony. And that brings us to the analysis and recommendation. Litigation counsel will not be able to meet the required burden of proof of alleged statutory and regulatory violations sufficient to oppose discipline in a contested case hearing based on the relatively minor alleged violations found in the reviewer's report, and given the inability to put on proof of the Chancellor or obtain a transcript of the Chancery Court trial. This report was one of the earliest ones prepared, and it's hoped that the level of detail and the content is improving from all reviewers, particularly after litigation and board counsel conducted a mandatory orientation with the reviewers in June of 2012. Based on all the above limitations, litigation and board counsel recommend closure of this complaint with the issue of a letter of warning for the respondent's cited violations of Rule 082004-02 and 082004-04. Now, having read all that, I think maybe we can hear it in simpler English from Mr. Joseph if he wants to tell you exactly what his experiences were.
Well, I think you summarized it well. The case came in 07. The Chancery Court suit was already pending. Okay, the complaint. I guess we put it in litigation monitoring for over 2.5 years, waiting on the outcome of the Chancery Court trial between the adjoining landowners. The complainant sent in a copy of the Chancery Court's final order in about January 2010, and the Chancellor did find what the report said, that the respondent's testimony was unreliable, that he relied more upon his client and the client's attorney in making his decision rather than the cause of the deed. The respondent, of course, technically, he wasn't a party to that lawsuit. He was just a surveyor. And he denied what the Chancellor found. He denied that he engaged in any misconduct, and he denied that his testimony was unreliable, and he denied that his work product was unreliable. So, even though we have a copy of the Chancery Court's order in a contested case hearing, the order in and of itself, the respondent can testify, he's not bound solely by the content of the order. So, given the case law that we've all related over the course of the past several months regarding the fact that we have to have expert testimony to prove a violation of the standards of care under our Uniform Administrative Procedures Act, pursuant to Martin v. Sizemore. And since we couldn't get a copy of the transcript, and that's very important, if we would have had a copy of the transcript of the Chancery Court trial, we would have had evidence so that we could impeach him. And this is what your testimony was before the Chancellor in that trial. We had sworn testimony. We couldn't get it. We don't have the right, given the fact that our office was not a party to that Chancery Court lawsuit. We don't have authority to get that transcript unless we get consent from one of the lawyers to that litigation. That's the way court reporters work across the state. All right? We couldn't get that consent from either of the two lawyers. Then I finally got the name of the court reporter directly. I called the court reporter. The court reporter said, Mr. Joseph, I don't believe that they ever ordered a copy of the transcript, so there's really no transcript in existence. So the ability to get the transcript was gone. We can't call the Chancellor in here to explain the basis of his ruling. We waited for months to get these contracts in for our complaint reviewers, expert witnesses, and my thinking at that point was that, okay, in order to satisfy our burden of proof, I'm going to send the entire file to the expert reviewer, including copies of the respondent's plat, the opposing landowner's survey plat, the Chancery Court ruling, and any other documents in the file, so the reviewer could review it all and give us an opinion. And that's what I did. I had expected to get an opinion that perhaps cited some of the provisions in Chapter 0820-03 dealing with your specific standards of conduct and what the technical problems were with the respondent's work product. I did not get that from this particular review. I only got, as we summarized on page 3 of 8, that he believed that the respondent didn't recognize the primary obligation to protect the safety, health, and welfare of the public, and that the public statements were not objective. Well, that doesn't really tell us a whole lot other than what's already in the Chancery Court's order. And compared to a couple of other reports we got, this one didn't have the degree of substance and detail that we really thought we needed in order to go forward. So, given the fact that it was my opinion, and Rob concurred, that had we gone to a formal contested case hearing, we did not think that the quantity of proof, the level of detail, and the substance pointed out by this reviewer would have satisfied our burden of proof. We don't believe we can go forward with a formal hearing in this particular case based upon what we've gotten thus far. A letter of warning is not discipline, and it does not result in a contested case hearing, so there doesn't have to be any evidence put on. But unfortunately, based upon everything that I've attempted to do in terms of getting proof, from the transcript through the complaint reviewer, and it doesn't seem as if the proof is very strong. This, unfortunately, is the recommendation that we've come up with.
Well, let me say this. I don't understand why the complainant's attorney would not have had a willingness to allow you to seek receiving the transcript. I don't understand that is a large question in my mind. Well, if this person was so adamant about filing a complaint against the respondent, and then when it came down to support that complaint, it seemed like all they would have had to say is, you know, Mr. So-and-so, my attorney, please let the state of Tennessee have this information.
Right.
Now I'm going to jump ahead just a more, so I want to say one more thing.
Right.
As far as the reviewer, which I'm not pleased with what I see here from the reviewer either, I'm going to make that point publicly known. Finding violations in our standards, I certainly could create a plat or a document that meets the strict letter of our standards from start to finish, and it create all kinds of litigation, all kinds of problems, and what's physically on the ground not even remotely match what I created. So I could create something in a matter similar to this that someone else, another surveyor, could review and say, well, there's no violations here on this document. But that doesn't mean that what I did didn't create or precipitate all this other stuff that's went on.
Yeah, that very well could have been the case. At the same time, and Rob and I didn't bring the file materials down here with us, the competing surveyor for the adjoining landowner, who the chancellor found was credible. The chancellor attached a copy of this individual's plat to his final order. You remember that, Rob? In which he had highlighted in some orange the major areas of error, and that there was a substantial amount of property that was not accounted for in the respondent's plat that damaged the complainant. And we thought that he would have been able to piece together from the opposing landowner's plat and the respondent's plat and the Chancery Court's order some more substantive analysis than this. Maybe we just weren't correct in assuming that. Getting back to the point about the complainant not having his attorney assist us in getting the transcript, that's a long, long story. Rob got this case handed to him at some point, maybe in 07 or 08. This individual, the complainant, is a very belligerent, or turned out to be a very belligerent individual relative to our office. And it's very difficult to understand. I don't know whether there was something else going on emotionally. I can't speculate. But between maybe 08 and 010, this individual might have called Rob's and I, our supervisor in the legal division, Wayne Pugh, and asked questions. What's going to happen with my complaint? When are you going to hearing? When are you going to do this? When are you going to do that? And really called and raised a whole lot of cane about the fact that we weren't doing anything. We weren't moving. And when I got the case in late 010 or early 011, I called the individual and I got the impression that he really did not want to cooperate. It made no sense. Why would you call our supervisors and complain that we hadn't moved on the case fast enough, and when were we going to do something? And I said, well, sir, are you willing to come in and testify and help me with the case? And then when I told him I needed the transcript, can you help me with that? And he got hot with me. He didn't know why I needed the transcript. And I finally was able to get in touch with his lawyer. His lawyer really didn't want to get involved. His lawyer didn't remember whether there was a transcript. His lawyer never, I asked him, could I have his consent? His lawyer never gave me the consent. So, to a large extent, the complainant waxed hot and cold over the years regarding the complaint. And when I indicated to him that if I felt it was necessary for me to have to subpoena him as a fact witness regarding all the things he put in his complaint and regarding his experience and regarding some of the documents he sent in, he said, why do you need to subpoena me? I don't want to testify. So he got to a point where he got adversarial with us and wasn't very cooperative, not to mention the fact that we just couldn't get the transcript anyway.
Well, one of the issues that I have with this scenario, Mr. Joseph, is the fact that in January of 2010, well, actually in the spring of 2010, this board or someone on this board had reviewed this particular complaint at that time, and this board made a recommendation of a civil penalty and the completion of a 2-hour ethics course, which tells me that whomever reviewed, I don't know if it's me or whoever reviewed that found that there was merit for a civil penalty to this individual. Now, and as stated in Rob's writings here, the consent order was not accepted by the respondent.
It wasn't accepted, no. It wasn't.
I as a board member, take that very offensive, very personal, because one of the things that we look at in our rules of conduct and we're trying to make some changes with is that very fact. If you're a registrant and this board speaks to you in a manner relative to discipline or whatever whether it's discipline or not, you need to respond in a timely and professional fashion to the board. And so, you know, I understand where you're coming from with the evidence, and I understand your explanation, but what I'm saying is, at that time, this board felt it was necessary to take an action. We took an action. The respondent would not accept the action, and then all this other stuff has occurred since then, and now, and I understand why you're asking what you're asking. Please don't misunderstand me. We're being asked to approve a letter of warning. I really have a hard time with that. I really do, because what this says is this board has already found wrongdoing above and beyond outside of that litigation, because to my knowledge this board didn't see that litigation, all the documents that you're talking about. Only the reviewer saw those documentations and the attorneys.
Right.
That's where I've got a problem.
Right, I understand that. Let me just try to, and I think this goes without saying, but I just want to state it for the record. At the time, and this is the case for every board and commission under the Administrative Procedures Act, at the time something is presented on a legal report for a proposed consent order, that's legally, you haven't found all the facts. This is just a probable cause determination. Okay? They're always going to, in getting the board or asking the board to propose a consent order, I don't think any of us as lawyers are saying these are going to be, these are the adjudicated facts, because we're not handling it. And all we're saying is, based upon what appears to be the case right now, there are alleged violations, probable cause. So that you have not reached what we call a crystallized point of view that this is definitely the case, because you simply don't know until or if there were a later formal hearing. But to be honest with you, the respondent did respond to Rob in a timely fashion. He did not take the consent order through his counsel. On its face, based upon the content of the court order, I can see why the recommendation was approved from a probable cause perspective. That's the reason why I sent it to the reviewer. And as a matter of proof, I simply am going to need more than just the court order. The court order can't be cross-examined.
The probable cause was the statement by the Chancellor of the unreliability. But we don't know exactly what was said without the transcript. And without knowing that, we can't have an expert look at that and determine and testify to this board that yes, what he was saying constitutes a violation. I suppose is about what it amounts to. Probable cause we have, it's just this is what happens when you try to actually prove it sometimes.
Well, the other thing is, it's very apparent from what you said, Rob, and you, Mr. Joseph, that neither of you is 100% comfortable with what you got from the contract review.
That is a clear.
And to me, I feel as though it's not been properly looked at by that expert witness set of eyes somewhere out here in the public that's a contract reviewer. And you know, my gut reaction is another one of those reviewers should look at it. Now I realize that's spending money, I understand that, but again, and the reason I say that is because this board took an action, whether it was 100% founded or not, for a consent order. So this board felt there was something there, okay? You all tell me you feel that there's something there, but you don't have that hard proof that you need, and I understand that. But at the same token, you tell me that you're not exactly satisfied with the reviewer's situation either. So, you know, again, my gut feeling is it ought to be reviewed again. Now, I don't know what the other members of the board think, but that's what I'm hearing. I'm not on a witch hunt. I'm certainly not trying to make sure that we bludgeon this respondent or anything of that nature. But at the same token, I want the respondent treated fairly. But if the respondent has, in fact, had a violation, I want him punished for his violation also, whichever the case may be.
Can I interject one thing? And this happened before I came on the board, but it looks like we were dealing with two different systems that started out here. First, the board was able to review the case.
Right.
And through the review of the case, the board made its recommendation. Now we have come in with the expert witness program and handed it off to them, and we've gotten a different view from the expert witness. And I'm kind of in agreement with Tim. I think that the board made its recommendation, and I, for one, would think that that we ought to stand behind what the board's recommendation was, because the expert witness did not have everything that what apparently the previous board had to review. And so I think that in itself should lend it to, okay, this is the consent order and this is what we still believe in.
I think the reason that we had involved the reviewer was because we couldn't get the transcript, so Jesse submitted the actual plat to see if maybe from that document we could assemble where the violation that was testified to might have occurred. Is that how we were doing it?
Well, right. I mean, we couldn't get the transcript so that we could prove exactly what the respondent's testimony was.
Right, and I understand.
So we understand that, but the submission to the reviewer was to say, notwithstanding what was in the Chancery Court's ruling, and we understand that that is not necessarily binding on the respondent. For instance, we could never compel the respondent in a hearing to come in here and we put on evidence of that Chancery Court ruling and not allow him to explain himself. He's not bound by that. I understand that. So we were asking the complaint reviewer to look at the entirety of the materials we were able to compile.
Yeah.
The respondent's plat, the respondent's written response, the complainant's complaint, the other landowner's plat, which was found credible by the Chancellor, and to opine whether he thought that there were violations of this board's rules and statutes. And this is what we came back with.
The problem there is, Mr. Joseph, is that if there's a matter of litigation, and Galen surveys for owner A, and his line is over where the windows is on this wall, and I survey for client B, and my line is over here where this wall is, okay? And we both present a document, and that is litigated in court, okay? Both his document and my document may meet every standard that this board has. There'll be no fallacies in those two documents. And then the court is going to decide wherever the line is, there, somewhere in between, okay? Well, from the standard of practice, neither he nor I did anything wrong according to the rules of this board. Up to, and I understand, up to when we actually testify, when we testify in that court, and it's how we represent what we say and so forth. And then that court rules, and that's similar to this matter here. The judge just simply repeated what he felt like he heard and put it in a document, which I understand that does not make that respondent actually guilty of those things without us having what his real words were in that transaction. And that's kind of what I'm seeing here. So what I'm saying on the reviewer's behalf is if he sees that situation, we're not asking the reviewers to ascertain where a property line should be in a matter of litigation. That's up to the court of law. But we are asking to review the document based on our rules and standards. But this situation is somewhat outside that a little bit. So obviously you're 100% correct that the critical component is the transcript. There's no question about that. But in this instance, if this board had not taken any actions whatsoever, then I think we would have been compelled to go 100% with the recommendation you and Rob have made in this particular matter. But, we've sort of already fought this battle once through the board process at that time. And now we're asking to fight it again, but we're asking to say, gee, we really didn't mean that. We didn't think that was the case. Because I don't see anything new here that tells me that we as the board should reverse what we did in 2010.
Well, I'm not asking to reverse it, and I'm not saying, but I guess what I'm suggesting to you is that based on the probable cause recommendation that was made in 2010, when you have the court order projecting forward for litigation, it would be assumed by anybody who's going to litigate the case that in order to be able to prove this at a hearing, irrespective of the question of the standards, let's leave that alone, that in order to prove that he had engaged in the conduct that the court put in the order, you would have to be able to get a transcript of that trial. Yeah. All right. That wasn't known in 2010. So it's really making a probable cause determination based upon the best information that you have at that time. Then looking at something in further down the lines, not necessarily saying you're reversing what you did, but can you prove what you did in an evidentiary hearing, in a contested evidentiary hearing? Can you prove it? And I just don't know.
Well, I would say without the transcript, it would be impossible to do.
And
it's unfortunate.
Yeah.
At the time when we made the recommendation, we expected that we would be able to prove the board's decision.
Yeah.
But as it turns out, that critical piece, we can't get it. So the probable cause remains. It's just that the piece of evidence we can't obtain to prove it. That's pretty much the way it is.
Yeah.
Mr. Joseph, you mentioned that the complaint has become quite adversarial in a relationship. Has he at any time in the past had other complaints
That he has filed? I have not researched that.
He is
The actual complainant in this case.
filed
Against
some other cases?
Surveyors? I'm not certain.
I don't know.
What's the respondent's history of complaints, if you can say?
Response is I don't know exactly how many.
I would just be curious about, because, you know, sometimes you find individuals that they like to go on witch hunts and they look for things that I would turn a blind eye to, because I think that
Yeah,
they're
but
doing that.
the fact that you have complaint history doesn't mean you've actually done anything wrong.
Yeah, I understand that.
Because that's just part of being a surveyor. In
Yeah.
a lot of cases, somebody's going to file a complaint.
I'm more concerned about the complainant rather than the respondent in this case, because he had a
History of
record of, hey, every time I get into something, I'm filing a complaint against the surveyor, then I'd say, what's going on here?
Well, I do think there is something going on because, and of course, in many instances, we can't make that determination, nor can Ms. Mulder and her staff, on the basis of the written document that comes in from the complainant, the signed complaint and the information. When I called him a couple of times about this matter, one of the times I called his house, and his wife answered the phone, and she had to go get him to the phone, and I could hear the background conversation, and she was telling him that, calm down, calm down, as if he was in a nervous, agitated state somehow. And that's when he went off on me about, why do you need to call me? I've done what I needed to do. What else do I need to do? I don't want to testify. I don't want to help.
Yeah.
So you do have some individuals that I don't know whether he submitted those kind of complaints before.
Yeah.
But some of those things you can't determine on the front end.
Right, I understand that. It would just be interesting.
Right.
Well, I'd say that based on what we have now, I don't know, and I hate to say that I'd see this board reverse what we had been proposed before, but I don't see any way that if we went forward from here to try to prove anything beyond this, and the best I can say is, I think you've come up with the best solution, and that is this letter of warning. And I hate to belabor this thing any further, because I don't know that we're going to accomplish anything by continuing on without ever having a transcript.
What's the word you use to maintain a file up and running?
It's closed, and we can return to it if something comes up relative to that case again. Dismissal means,
That's new information.
right, if something bears on
In
this
other
case.
words, if the transcript shows
The
up.
transcript showed up.
Yeah, we can reopen it.
So if we can close it and then have the opportunity to reopen it if something would come up, then I don't really know of anything else that we can do about that.
Now, judging from the disposition of the complainant, once they're notified that we've closed this with a letter of warning, suddenly new evidence might come up because they'll be upset about that.
It might be.
And maybe this is one way that we can generate some more evidence.
That's
We
a
don't
real
know.
possibility. It could happen.
Why did you close it with the letter? It's like, I got this here, you know. It may turn out.
Why didn't you present that? You know, so, anyway, I mean, that's my opinion.
Sue, you have anything? Okay, having concluded the discussion, if no one else has anything else, the chair will entertain a motion in this matter.
Well, I move that we accept what our attorney has given us, and whatever the document is that we need to send out in that letter of warning, that we do that.
Do we have a second?
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Opposed, likewise? Okay. All right.
Mr. Chairman, it's 10 o'clock. Do we have a 10 o'clock appointment?
Yes.
Would you like to suspend the rest of the report to
Yes.
indulge our guest?
If it's all right with the board, let's take let's suspend the legal report at this point in time. We'll return to it after we have our discussion with Mr. Campbell. But at this point in time, we'll take a 5-minute recess, and we'll reconvene at 10 o'clock so we can be on time for Mr. Campbell's meeting.
Well, why not?
That's okay.
That's okay.
Be quick.
No, that's fine.
I've got some other errands here in town that I've coordinated with this trip, so.
Okay, well, let's reconvene this meeting of the Board of Examiners. We have a visitor with us today, Mr. Eddie Campbell. He is asked to come and speak to the board about unlicensed practice. And Mr. Campbell, thank you for coming. We appreciate your interest and concern, and we're here to listen and hear what you've got to say.
All right. Well, I appreciate you, and I'm James E. Campbell, registered land surveyor number 1682 here in Tennessee. My friends call me Eddie, obviously, and I count Galen as one of those for sure. But I want to thank you first for sitting on this board, because I know this probably happens at some inconvenient times for you now and again, and for the state and for the profession and for the public at large that you're hoping to protect. I'm not here to provide any particularly new information on the subject of unregistered practitioners, and I'm not here to complain about any particular instance or individual. I am here to learn more about the board's function regarding this issue and to hear of maybe some opinions on a few matters. I'm not here to promote a particular solution to this age-old issue of unregistered practitioners. You might say I'm here with an unsolicited report from the trenches. For the past couple of years, I've been presenting continuing education seminars at a lot of locations around the Southeast, and I've had a pretty good audience from all over the Southeast and the Midwestern states east of the Mississippi. I had a gentleman from Chicago last week to come down, and pretty much everywhere the adjoining states. And that's put me in personal contact with a larger than ever, for me, number of land surveyors, not just from Tennessee, but from surrounding regions. Either in person or by telephone or by email, in either presenting or promoting these courses to my peers. And we are a profession, I feel, that's in trouble. If we were a species, we would probably be on the endangered list. I think that's a fair statement. I hear of surveyors closing businesses and seeking other careers after putting 10, 15, and 20 years into land surveying. It's funny, we mentioned Piney Creek. I brought it up not meaning to bring up Wes Johnson, but Wes Johnson, who I sponsored and worked with for a number of years before he got his registration, and is a good surveyor, has given up on the notion of surveying and is going in another direction entirely. After putting half of his adult life into that. But I personally remain faithful in the value of what we do and the services that we provide. I believe that an economic recovery is on the horizon. I believe in the United States, and that the demand for our services is at a monumental turning point, due both to this imminent economic recovery and also to the technological advances that are related to surveying. We as surveyors are adversely affected or infected in at least 3 ways by unregistered practitioners. I'd like you to consider them with me. The state of Tennessee, surprisingly, particularly TDEC, accepting documents that are, as I would say, area sensitive, areas and fractions thereof, going to the definition of surveying with erosion control, permitting, and also the compliance with the Safe Dams Act, etc., etc., etc. Not just that organization, but others. Then the second way is through the geospatial technologies, GIS, as it's loosely called. As I mentioned, there's really no new surveyors needed, but when I look at statistics regarding career choices for young folks, and I have a daughter entering college right now and making that choice, geospatial technologies seem to appear at the top or near the top of the list as a good choice. And I think we've lost sight of the fact that you can't be geo without being survey related. As evidence of that, I feel like we are the prefix geo literally means the earth. And geometry, that word originally meant the measurement of the earth. And I think at a minimum we're still charged with the measurement of the earth by our definition in many other states, and ACM has an idea on what surveying is, and I think that certainly the measurement of the earth is what we still have. Also testament to the importance of this and the word survey. The National Geodetic Survey's predecessor, which was called the Survey of the Coast, was established in 1807. It's the oldest scientific agency in the federal government. But they're serving, I think, the senior geodesists and whatnot that I've spoken with at NGS and listened to their seminars and webinars, they are speaking more to the geospatial community than the surveying community. And I feel that geospatial, although it's so far hasn't been, I think that should be drawn under our umbrella. I think that surveying, the surveying business without a geospatial component is unthinkable 10 or 20 years hence. I think that will be a big part of our business as surveyors. So I feel like that should be brought under regulation, and I don't know who that needs to be, but I feel like that it should be considered as part of the surveying regulation. Again, by definitions, if you take the definition of surveying, the accepted definition or definitions, and the accepted definition of geospatial technology, there's many overlaps. It's almost like you're talking about the same subject matter. Exactly. And the third way is from within. Here's where I'm hoping to improve my understanding of the line between mentoring and selling your stamp. Our own professionals, I feel, at times are helping others to circumvent the registration process in various ways. And I know that's addressed in the rules. I don't know what the solution for that is. I know that it goes on, but it is a terribly sore spot because many of these fellows are very likable people, and it's really going out on a limb to point a finger at a peer, as you well understand. So I guess I need some guidance on what's the board's stance of where that line between mentoring and selling your stamp lies. And as I mentioned earlier, we're in trouble. We're at a turning point, and it seems to me that at a turning point like this, where we're deciding, those of us who are deciding to stay the course and stay committed to our craft, so to speak, is this not an ideal time to deal with an issue like this? And in conclusion, I want to thank you, and I'd like to hear what your thoughts on the subject, either verbally today or in writing or whatever the appropriate means may be.
Well, Mr. Campbell, thank you very much. That was a very interesting and very to-point presentation. I would like to say to you in response that this board has been given a charge a few years ago to try to bring our rules and our standards up to date. Most of our rules and standards were last revised in the mid-90s. So that's almost 20 years ago now. And that's unacceptable. So we've taken that charge on. The first rule that we dealt with, as you're aware, was their standards of practice. Now, as we found in that process, that we were not able to truly get to the standards that the board at that time really felt like we should move towards. And part of that process came about simply because if you regress in survey methodology back to a transit and a chain, the legislature looks at regulations and standards in a manner that if there is one licensed surveyor in the state of Tennessee that still uses a transit and chain, can he achieve the standard that you're asking him to live up to maintain his professional registration? Now I realize that's quite a stretch, but that's an example that I have to bring forth because one of the many things that we deal with in trying to update our rules and standards is what the economic impact is, particularly to the small practitioner. Obviously, we're not talking about the norm or the large, but generally it's the small. So we have to take that into consideration. And I just simply use the transit and the chain as an example to simply say that yes, we've progressed, but we're not past that point real far, to be quite honest. And you as a fellow professional certainly understand where I'm coming from when you look at the minimum standards and it says one and whatever and so forth and so on. You know, the way you probably run your practice, and I have no idea, you probably far exceed that. Most professionals do. But the legislative process kind of restricts us from getting to where we would all really like to be, or are actually practicing within. We're continuing on that path of changing these rules. Where we're at right now is in our rules of professional conduct. And in the rules of professional conduct, deals with some of this unlicensed practice, along with some of the current practice that professionals are doing. What we have found in our what we call the Blue Book, which everybody's pretty well used to, even though it's all on the internet now. What we found is we simply did not have enough teeth in our conduct definitions and then the punishment or penalties thereof. So we're trying to wrap our arms around, to the fullest extent that the legislature will allow, around those issues, so that what you see, if we get this approved, will be a much better environment for all practitioners. It will basically do what I try to stress is level the playing field, so that everybody's going by the same set of rules. As you mentioned, the mentoring and the buying of stamps, that's certainly the case, and we're all aware of that, and we're trying to get to where that's not the case. It's not the norm by any way. That it's a situation where we have a more structured regiment for the unprofessional coming along, and when they get there, then they are more of a professional when they do get there. You spoke also, I took a few notes, you spoke also about TDAC, for example. I've said many times that our profession as a surveyor is more regulated by more entities within the state of Tennessee than most people really realize. Not only TDAC, but you look at planning commissions, you just start looking around and you have all types of different entities that basically tell us how we're supposed to do our job. Even to the extent if someone orders an audit survey from you, they're going to tell you how you're supposed to do your job. Well, guess what? You've got to man up and say, hey, look, the state of Tennessee says, so I've got to do that first and foremost. And now we'll talk about your job. Again, it doesn't always happen. It doesn't always happen. So, yes, I'm very much in concurrence with your statement that we are a profession that is multi-regulated well beyond the rules and regulations that we have. And we see that all the time, and have a lot of questions about it. One thing that I do want to point out that has not been real common knowledge among our professionals is when we passed our new standards of practice, we passed a section called remote sensing. That section you need to focus on and read very, very diligently and slowly to digest and wrap your arms around. To this time, since that has been passed and put into our rules and regulations, it's not been tested. But it goes to the extreme of basically stipulating that a construction company with construction grade GPS and so forth on their site basically should have a licensed land surveyor doing that work. That was the intent of that, and it doesn't clearly spell that out word for word as I've stated it, but that's the intent of that, of having that in that remote sensing area. It also, I think, addresses GIS and a couple other things right there. And that was our first effort in reaching out to try to address some of those particular issues in that geospatial world that you referred to. But like I say, it's not been tested in the court yet, or we've not been pushed on it through a complaint or anything of that nature here at this board at this time. We will, I'm sure, in the future. But that was where we were going with that. That is also a precursor for what I hope in the future will allow us to reach out and license not only GIS folks, but photographers, as many other adjoining states have done.
Right.
Again, taking a better hold on the world that we're really the foundation for. We're the foundation for photographers. They need us doing that ground control and so forth. We're the foundation for the GIS, as you well know, because without survey grade data in a GIS system, you don't really have a whole lot. we've got something that's a little more vague, to say the least. And I've seen many issues and problems with the local GIS information, especially to the public, and I really don't feel like that is being addressed well enough. And I hope at some point in time, maybe in my tenure, that we'll be able to reach out and try to address some of those situations and get those folks licensed under our umbrella, as they are in many other states that are joining us. I got one more thing, and I won't hush and Galen talk about it. But you also, going back to the mentoring or the stamping situation, one of the things that we're looking at, one of the items that we'll discuss today on our agenda, is the possible elimination of the 10-year experience rule, particularly relative to Tennessee. And we have had discussions in the past of potentially extending the experience requirement from the 2 years to something else. So we have not certainly turned a blind eye to that scenario, because the 10-year rule in itself, I think, has somewhat hampered us and limited us in being known what I call as a true professional. I know the statement has been made, as long as you get guys out of high school or get a GED and they work for 10 years, how do you want the public to perceive them as professional, even though they may be an outstanding individual and surveyor? But the far-reaching aspects of that are not what we're all here. It's not what we're about. You know, we went to all the efforts to get the 4-year degree to help us become a professional. You know, we need the experience that comes with that, so that, you know, anyone that meets Rob and he's an attorney gives him the proper respect, because he's an attorney. He's a professional. Okay. You and I don't think get that from the same peer group of people that would give him that respect. And now that's my perception. We may, but not always. So, you know, surveying, I know on my end of the state, is still perceived somewhat as trade quasi-professional. You know, the unfortunate thing about surveying is that we have a large physical component. You know, we've got to be out in the woods and climb the mountains and cut the brush and go through the creeks and drive stakes and all this kind of thing, where many other professionals don't have that extensive physical component. But yes, you're right. We need to be a true professional. And I just want to assure you from my situation here that the board is trying to make strides toward those things. But as we strive and strive towards anything, we're in a 1 to 2 year window in most any type of legislative action that we're involved in. And yes, you're right. We need to be forward thinking, and I think this board has done so far, and I think we'll continue to do that, to try to reach as far forward as we can to make it better for each registrant, to better protect the public, and have a better registrant to serve the public. And, you know, that's my goal, and I think that's the board's goal. But that's my take on what you said.
Thank you very much.
I'm going to give it to Galen or Sue.
I don't have much to add to what Tim has already said. I do think that as a board that we are considering changes that I think would obviously be beneficial to the profession, and taking out the unlicensed surveyor. We may not have reached that pinnacle yet as to what we envision as to be the goal that we want to get as far as in our rules and what have you, but the strides that we have made, thank goodness we have made those right now dealing you know, with remote sensing, because for years we sat back and watched various companies come in with their equipment and do the work that the surveyor should have been doing. And sometimes to the detriment of the job that they were working on, because individuals did not know how to handle that equipment. And I trust that we in this board and this profession are training the men that are coming up and the women that are coming up in the surveying profession to know how to handle that equipment and say, hey, I can do this, and let me, as I work for your company, let's keep things straight and stay within the guidelines that have been presented in the standards of practice for remote sensing work. As far as another government agency dealing with us and telling us what we have to do, or telling the individuals in under their particular oversight, I can tell you that I have discussed with various entities dealing with TDEC, and Tim is aware of it. The story dealing with them going out and locating sites on the ground for, just tell you, for septic systems and what have you, and not being licensed surveyors. And I laid the definition out to them, and that hasn't been tested. We'd be glad for the soil scientist to go out and do that, as long as he comes and takes the surveying exam and passes it, then he can go out and locate those sites. But I can't tell TDEC not to go out and do that. I'm just saying, here it is, folks. Surveyors are limited by the fact that we are not considered the professionals that, by definition, that we would know, because we can't do engineering work, but yet most of us are very capable of doing drainage work. And those that choose to do so do a really good job, and we test on that, whereas the engineers don't test on it, but you would have to go to the engineer to get that drainage work done. And obviously it has been ruled that the engineers are correct in this case until such time as we obtain professional status, and that is the 4-year degree, and we get rid of the apprentice type program. And so from that standpoint, I wish we had some good solid ground to stand on to say, hey, yeah, the law says that we can do this, and I trust that we are, as a board, that we're moving in that direction to make sure that we have that ground to stand on. And I agree with Tim. We've made strides, but we're by no stretch where we would like to be. But we have in front of us today and tomorrow and the agenda some things that we have to consider that are rule changes, and we're going to work on those particular things. And as we go through them, then they will be made public so that the profession can take a look at them and probably give us input as to what we need to do. We look for help. If you want to help us, then I appreciate what you have said, because at least I said somebody out there has their eyes open to the fact that this board, as good as it may be or as bad as it may be, are trying to make strides to help the profession. And I've been in it long enough, you've been in it long enough, Tim's been in it long enough to know that we do need the comments from those folks, instead of sitting back and not doing anything, being apathetic about our profession. Be involved, get in there and say something to it, and take a stand and help us with this thing. Because, we can't fight the fight alone.
I'm certainly available to help, but I don't know what that process entails, but I'm available to help. I'm not going to just raise the red flag, here's the problem, and then let somebody else take care of it.
I understand. We need a solution. If you know what the problem is, give us an idea about the solution.
Right. And in regard to 2 chapters we're dealing with rules of conduct. Hopefully, in this meeting or the next meeting, we'll be able to get that out and set for public hearing. And when you see that, please review it. Get your peers to review it. And if they have comments, either send them in writing or come to the public hearing, because just because we've set forth a document with changes and so forth on it, does not mean we may not have overlooked something, or maybe we added something that really shouldn't be in there. We really want everybody's input. We want it to be as comprehensive for the profession as possible. We're getting ready to go back to work on continuing education, because I know you give seminars. That's kind of a political football in its own little right, So certainly your input there will be valuable. I want to say one other thing about your unlicensed practice situation. In our rules of professional conduct, before I sat on this board, I always struggled with the fact that in 0820-4-02 section paragraph 2 that it said a registrant possessing knowledge of a violation should report the knowledge to the board in writing and cooperate with the board. You know, I really struggled with that until I sat on this board and had a much better understanding of what these rules are, why, and what goes behind them. And yes, I understand that if you turn me in, I'm going to be mad, and the first chance I get, I'm going to turn you in. But that has been the mentality for too long. The mentality should be that if you're not doing what we're supposed to be doing, then you should be turned in. And if you need a reprimand by a letter or a fine or whatever, then hopefully that'll make you a better surveyor. And my theory about that is, if John Doe in City A is turned in because he's not doing according to what he's supposed to be doing, then everybody else around City A is going to find out about that. Because, you know, we publish these things now. And when they find out about it, their thought process should be, what did he do wrong? Now, am I doing the same thing? Do I need to look and see if I'm doing that, maybe I need to fix that, or do I need to just kind of take a quick look and see if I'm doing something else wrong that maybe he wasn't doing wrong? And in my opinion, that is positive for the profession, because one person doing something wrong may correct half a dozen others. I mean, that's kind of an odd way of looking at something, but having sat on this board now and dealt with these things and these legislative reviews we do and so forth, it's just made that more pointed to me. You know, my approach is, if I have a surveyor in my area that I think is doing something wrong, or I come up with a survey joining him and I got problems or whatever, I pick the telephone up and I call him and say, hey, look, you know, I got a problem, whether it's on the survey line or whether it's on his map or whatever it is. I just pick the phone, call him and say, you know, can we talk about this or whatever? Well, if the surveyor is a professional, he should, one, be interested, and two, listen, and three, hopefully respond in some form or fashion, whether it's the response I want or I don't want, but respond. But if that surveyor chooses number 4 and just sort of blows me off, you know what? I'm going to send that letter in. I'm going to send it in because he's telling me that he doesn't want to be a professional, because I've extended a courtesy to try to help him as a fellow professional, to just to see, you know, maybe I'm the one that's wrong, you know. And if we can talk about it, we'll figure that out. But if you know, if you blow me off, hey, I'm going to do what I'm supposed to do under the law, and I'm going to move forward. Now, that may be too hard line sounding, but I feel like that I've extended my professional ethics and courtesy first, open the door. But the other party's the one that slammed it in my face. So we'll move on to the next step. And if I get known to a bad guy because of that, so be it. But somehow or another, out of each and every case that we review and each and every action that we take on those cases from this board, based on the facts that we have presented to us, I hope that it not only rectifies the situation with that individual that we did an action against, but also other individuals that find out what happened to that individual to help them become better in their profession and day-to-day practice. So I just want to throw that out.
Well, I appreciate it. And that's the very sentence, you know, that's the one.
Yeah.
And
That's the hard one.
That's the hard one. And, you know, you hope that a lot of these problems go away through attrition, but that won't take care of 100% of it.
No.
And that's...
Now, everybody has a surveyor in their area that they're just hoping we'll just retire and that'll go away. They really do. Everybody has one of those.
No question.
And that's unfortunate. It's unfortunate, but, you know, as you said, hey, times are changing. We need to be more proactive, more progressive, and unfortunately, I just feel like that's part of the puzzle that we got to do.
Absolutely. Well, I'm glad to hear that's your first effort. So that's your iteration number 1 on the standards, and then you're moving on to these others, and then you'll be revisiting the standards and that sort of thing. I'm glad to hear that. On the GIS folks, you know, as Bill Henning, the geodesist, he's the guru of GPS, I guess, in the United States. He made a statement I heard recently: accuracy is contagious. You know, there was a time when GIS required 10-meter accuracy, but now they're getting into the centimeter world, and they're misunderstanding some things. And rarely do you see a GIS inventory of utilities that doesn't show parcel boundary lines. So that's all in our business, and I'm glad to hear that you're considering that. I'm glad to hear the take on remote sensing, because I've read that over and over and over, and I wasn't sure exactly where you were going with it. I'm glad to hear.
Well, you have to realize that, you know, anytime we send anything for a legislative process, there are tons and tons of lobbyists that we deal with that have eyes on it. And sometimes you can't always say what you mean, if that makes any sense.
Yeah, because they're watering it down for their own best interest or personal interest. The 10-year rule, I am not against or for that. I am puzzled about, I think if you added the LSIT component to that 10-year rule, it would be better. The 10 years flat experience and getting 3 surveyors to sign saying you're capable, I don't think is test enough in this modern time to screen off what we're looking to screen off. I believe that either eliminating that, I would be for eliminating that, or at least adding the LSIT component to that 10-year rule.
Well, I think I can say this in the public meeting. We have an Attorney General's opinion in 2004 relative to drainage, which basically found against surveyors doing drainage. And it is my opinion, and this opinion is somewhat founded, that until the 10-year rule is eliminated, the Engineers Board will not consider surveyors reapproaching that situation any whatsoever.
I see. Okay. Well then, I think it's probably a good move to eliminate it. It's, but that's one opinion, and I swore I was going to stay away from the one opinion thing. I agree that the 2 years is not long enough, even with a bachelor's degree or a master's or a PhD. The 2 years experience is not enough, and I believe that I haven't personally, but I know surveyors who have hired folks from the ETSU program, and I think they would concur that 2 years is not enough on top of that. Ethics, is it possible? Is it possible? A lot of the surrounding states are requiring ethics, and also I speak to board members in surrounding states, and I believe many of the surrounding states are applauding your move on the continuing education being contact hours as opposed to video and online. That was almost like a second registration fee. I believe that other states are going to be following your lead there. But should we give ourselves a fighting chance with an ethics requirement for continuing education and a standards of practice requirement, or am I just ignorant to what you're already doing?
Gail and I are both smiling as you say that, because that is one of the key components that is included currently in our draft for the continuing education document.
Fantastic.
I've spoken very vehemently about it since I've been on this board, because I'm licensed in Kentucky and in Georgia, and both of those states require that. And I feel like that it's very, very important that the surveyors be appraised of the do's and don'ts ethically and by standards.
Yeah.
Now, they're not, the standards courses in these other states are not the most enjoyable seminars to sit through, because you're basically read the standards. But again, the key to it is, follow me. When this blue book was published and mailed out to the surveyor, every surveyor in the state of Tennessee received it, okay? And they had no recourse to say that they didn't know what the rules were, okay? Today, we are back in an environment of where they're wanting to say they didn't know that the rules changed. Because why? We don't publish the blue book. It's now on the internet. Yeah, they're mailed a copy of the rules. But we're still in an environment of where there's some doubt or questions in some people's mind about totally doing that. So instituting the ethics and standards as part of our continuing education basically takes that away from everybody again, because everybody in a 4 or 5 year period of time or whatever has got to sit in that class and take that class and got to hear it. So at least every 4 or 5 years, whatever the magic number is, they're going to hear it. So they can't come before the board in a matter and say, well, we didn't know nothing about that. How are we supposed to find that out? We live down here in Timbuktu too, and the sun don't shine down there 2 hours a day.
Yeah.
You know.
And we'll be getting the same book with the same rules for 20 years.
Right.
That's a fair argument.
Right.
That there hasn't been a change in 20 years.
Right.
I just put it on a shelf like I have the other 20.
But just as I very briefly defined the remote sensing portion of the standards of practice to you, that's the kind of thing that can be expanded upon in a seminar of this nature to the registrants, and then they understand, and they can take it and take that and go forward with it.
Yeah, well, the courses I've been teaching, and I'm going to let you go and get out of here, but the course I've been teaching, I bought into GPS in the early 90s when it was still a pipe dream, as my daddy would say, and was never going to work. And thus I've been involved in the geodetic side for quite a while, and that's the courses I put on is geospatial technologies and GPS technologies. And I'm finding that surveyors as a group have some misconceptions in those technologies. And I'm also hearing a lot of feedback, not all positive, about the new section on remote sensing and that sort of thing. So if it's okay, I may try to put together some various points of view that I've heard in my own in a letter or something.
I would say that on the GIS situation or the GPS situation, the recommendation that the board had from the TAPS committee was basically not to include anything on GPS. But the board pushed very hard to include something on GPS because it's my opinion that if I do a GPS survey, then 10 years from now you come along behind me and my survey states it's GPS and so forth, you need to know enough basic data to be able to recreate what I did.
Retrace it.
We all know that when we're doing transit chain or EDM, total station robot, whatever, but GPS is another animal. So we still need data to know how to retrace that so we can find those same points or replace those same points. And that's why that got put in the standards of practice.
Yeah, well, I was glad to see it. I feel like it needs some expansion, some tweaking, but I was glad to see it introduced because it's a fact of life, and it has been. The sad part is there was a gap from the early 90s to about 2001 when everybody got GPS. But most surveyors are treating GPS just like a total station. They're dumbing it down, and they have a lot of misconceptions about datums, or they're totally, I find some are just completely ignorant to certain datums and the shifts and everything that may happen with time. And it's been interesting out there listening to comments and points of view and working with the surveyors. I've enjoyed it. It hasn't made a nickel, but I've enjoyed doing it. And I just do small groups, and I feel like I get some valuable input, and I may be trying to pass some of that on to you folks.
there again, Eddie, as we put this into our law and standard of practice, there was nothing in there, and so we needed something, and the surveyor felt like that we're being left out, and if we don't get on this donkey and start riding this thing and get this thing under our oversight, then it's going to be taken away. And it is part of, and we use it as part of surveying because we use it to measure the earth, obviously. And so our attempt was to, without ruffling the feathers of other entities, lobbyists and what have you, we went this route to get this thing put in here so that we would say, all right, this is remote sensing. And what is remote sensing? Well, it's GPS, if you really want to know. And what is GPS? Well, it includes everything that falls under that label, whether it's GIS or whatever else it might be. And I just think that was our initial stab to make sure that it fell under the surveyor's oversight. Now that it's under the surveyor's oversight, then we can begin to expand on this thing. But without something being there, we didn't stand a chance to continue on with this.
And the good part about it is, I'm going to call it an optional technology, whereas our basic minimum standards, again, going back to that transit chain, or that theodolite and tape, or total station or whatever, those are all within one box, okay? When you shift over to GPS, it's a whole other thing. It's an option. If you're able to afford it and to use it, then you got to do this, this, and this, just like these other guys do. But you're not legislating these guys out of work. It's somebody that got a little bit more wherewithal to get the next step. So that's
sadly it's black box technology, and their surveyors as a group are relying too heavily on salespeople for their advice on how to use the equipment.
Yeah, I think you're exactly right, because this is what it'll do. Well, they have only told you the dumbed down part of that. They've told you, oh, you can use this instead of using your robot, your total station. You can use GPS, and it'll go a whole lot quicker, and then you can do all this other thing. And that's fine. I'm glad to know that. But it is so much more capable of doing a lot of things. I have it, and I hate to admit, but I'm one of the ones that's ignorant about it. And I use it. I love using it. It's not for everything. And I think the surveyors need to know it's not for everything, because there are some out there that are using it for everything.
It's not a magic box, turn it on, and all the results are perfect every time.
That's right.
It's not that. By no means.
I've seen the horrid look come on surveyors' faces in the room during these courses over the last couple of years when they realize that they've been doing something wrong for a long time. Because that's every surveyor's nightmare. But anyway, I appreciate y'all, appreciate what you're doing, and I'll try to correspond with you some.
We thank you for your time coming and speaking to us, and anytime you have any comment or want to come back, whatever, feel free to. We'd be glad to hear what you got to say.
All right. Appreciate you.
Thank you.
Good to see you guys.
Okay. All right, I guess we're back to you, Rob, to continue our legal report.
Okay, next heading is case under reconsideration. Only one. Case number 2012-006091. This matter was previously presented at our last meeting in April, and the substance was italicized as verbatim what you were told. To plain alleges unlicensed practice in land surveying by advertising to offer detailed technical sign surveys, as-built surveys, and construction surveys in various online media. The respondent company also appears in phone indexes under the designation of surveying engineers and land surveyors in violation of the statute. A detailed explanation of actual services provided was received by the respondent, from the respondent. The respondent states that the primary business is nationwide commercial sign surveys. in which the company is contracted by major sign manufacturers to survey sites for replacement of existing signage or adding new signage. The respondent provides digital photographs of property, approximate measurements of any building on the property, and provides a manufacturer exact measurement of all signage on the property of the building. And finally, we provide the client with an as-built survey package as the end product with information for these companies to secure permitting. The respondent acknowledges that he doesn't have the credentials or expertise to provide land surveying as defined by the board. The listing in the phone index under surveying engineers and land surveyors was done by the publisher and without the respondent's participation. And there's no complaint history for this respondent. So at that time, the determination of the board was that the respondent is to be notified that he's to comply with all board law and rules, and the respondent needs to provide proof to the board that he has complied. And our update is an acknowledgement letter was received in legal May 25th, confirming the respondent's intention to comply with all the board's law and rules and his correspondence with the publishing authority whereby that publication has moved the respondent's advertisement from surveying engineers, land surveyors to signs as requested by the respondent. Okay, the recommendation is that the respondent has met all the board's requesting criteria to terminate this particular matter, so the recommendation is to close the case. He did what we asked him to do.
Okay, bring it back to the board. We have any discussion? Do we have a motion?
Make a motion to close the case.
Okay, we have a second?
Second.
Okay, those in favor?
Aye.
Okay. Close the case.
Zills keep shutting off. It's got this every 5 seconds.
Magnetic personality.
It's bad because I'm using paper. But I can't make notes on this screen.
That's right, you can.
Yeah, I hope Don will give me a legal report after a while, so I can think I'm
All right, next case. Case is under complaint review analysis. Now, the way I'm going to do this now is when I send the matter out for, and as you know, some are better than others, as we've experienced, and this is one of the good ones. Send them the materials, the allegations, and what particular law or rule has been violated. And they look at it in that context. So what I've done here in reviewing his report is I've actually listed the rule and how the facts relate to it and what the person that reviewed it found. So, number one is 2012-000811. This case was referred to a contracted complaint reviewer for analysis because of the allegation of incompetence in the respondent's professional practice of land surveying and possible violation of TCA 62-18-127, which is the duty to research common boundaries. Tennessee compiled rules and regs 0820-0403A, which is malpractice, for committing reckless or excessive errors or omissions. Specifically, the allegations that the respondent overstated the acreage of a parcel while developing a land survey and created a boundary dispute, amounting to a gross and costly error resulting in significant overpayment for purchased property. Briefly, the respondent produced an original, which is the inaccurate survey, and adjusted it to suit the complainant's suggestions, and the complainant filed the complaint to make the board aware of this professional conduct. And there's no previous complaint history. So, because this respondent apparently adjusted his previous plat based on the complainant's suggestion, the complainant himself reported this because he didn't think it was right. All right, the first alleged violated rule is our survey types and requirements. The case reviewer identified the following possible violations of the above rule. These violations consist of descriptive location of the property or vicinity. Map is not shown on the survey. The survey does not meet the standards of certification because the ratio or precision of the unadjusted survey is stated as exactly 1 to 7,500. Number 3, the names of adjoining landowners and deed references are not completely shown on the survey. 4, material and size of found or set monuments are not shown. All right, moving to the next rule in question, 08-2004.09 is the land descriptions. The case reviewer analyzed the allegations relative to the above rule and found that the survey does not name all adjoiners and deeds and the size and types of property corners. The fence line shown in the survey is not included in the description as to its type, boundary line, or convenience. All right, the case reviewer's analysis creates a professional opinion that the respondent committed several major mistakes in the original survey, and most surveys, the original and the corrected survey, contain major errors in 2 locations, and all bearings between the 2 major changes were rotated at the end of the first call to a fixed point. The respondent stated that he reran the survey on proper points. However, the distances between points starting at point 1 to point 2 as marked on the corrected survey matched the original survey for distances. This leads the case reviewer to conclude that an inaccurate closure created the problem with increased acreage. The responder's statement about first using the wrong side shots is not supported by the land descriptions and revisions to the survey. So the long and the short of it is, I think he identified enough things that were wrong that some kind of probable cause exists. And the recommendation is to let you decide how severe these are so we can set a proper penalty to incorporate into the consent.
Apparently, the surveyor did in fact do a land description.
No, this reviewer's pretty good. He described the profession as best he could, so I can relate it to you without having you actually look at the documents. If we go to a formal, you're going to be quite aware of everything that happened. Our purpose here is to give you sufficient cause to decide that something's wrong. Now, using your professional judgment and looking at what this person did, I'd like to ask the board to recommend to me how bad this is.
The one thing that I struggle the most with, Rob, is where we apply, for example, these are in the standards of practice,
Right.
where we apply those in the civil penalties. Because the civil penalties speak to TCA number, and these are an individual inside a chapter number. And that's the one I've always, ever since I've been on this board, struggled the most with, is how to interrelate one to the other. I can understand it's wrong, but I don't know how to relate it to the penalty.
Well, let's see if we can find something. Okay, that's on page, well, I don't know, these are numbered as per page.
And most of the ones in standards of practice give 62, 18, 105, or 106
Which is,
as their TCA, but then I go over to the penalty section and I don't see 105 or 106.
thank goodness we have our discussion of legislative wish list today. Because this is a kind of thing. Of course, we can change this in our rules. Okay, the board may review the issues. Okay. Any income? It's 116 A1B. Incompetency, misconduct, or gross negligence, or C, which is any violation of this chapter or any rules, is a statutory grounds for discipline. The violation of 116 is in our civil penalties.
Yes.
Number B. So, I suggest, and you don't have to follow my advice by any means, we've got 1, 2 specific rules that it looks like this person is allegedly violated. So you can attach a value. You can make these 2 rules 1 and 2, and like a $2,000 civil penalty. Or you can break it down, if you wish, into the particular things think under the first rule, 1, 2, 3, 4 problems were located. And I guess under the second rule, probably just 1. So that's 5 violations, if you want to look at it that way. That's what I'm saying. I just want to see how you want to analyze this so we can set a precedent, not violate a precedent.
Well, the fact that he may have made a mistake of side shots or whatever doesn't affect these things that have been determined as violations, because they're what I call boilerplate.
I'm going to say anybody can make an error on a side shot.
Yeah.
And write it down wrong, punch it, and it didn't record, and they did something else. I'm just saying that doesn't constitute an error. It's
Right.
this other stuff that constitutes the error.
Well, what does the board think? Do we want to look at these as individual violations and penalize them appropriately, or do we want to look at it collectively?
Yeah, you can say this is all one violation. There's been 2 rules violated, so there's 2 violations, or you can even break it down one way.
My notion is we look at it collectively just from this standpoint.
I agree with that.
In other words, for example, let's just pick one. If item number 1 in the first violation, our description, location of the property, vicinity map is not shown in the survey, if we assess that was worth $250, just to pick a number totally out of the air, then all of a sudden we have to start living with that.
Yeah.
The next guy comes along, he's got $250.
Yeah, I agree.
If we look at it and say, hey, look, there's 5 or 6 things wrong with this thing right here, and we think that it's this amount. I don't think we tie ourselves down to getting into too many specifics.
That's why I like y'all to be very careful about, because you're setting precedents for
Right.
yourself.
Right.
I agree with Tim on that. Totally.
And then my cover letters in the consent order itself, I enumerate in there exactly how you arrived, whatever you arrived at, so we don't work arbitrary. Because like the chairman says, everybody's got to be treated the same. We're a force of nature, we don't pick people, we decide to hammer out.
So if I understood you correctly, Rob, we're in probably 116D there, so we're in the $50 to $1,000 range for each of these 2 items. Is that correct?
500 to 1,000.
Oh, 500 to 1,000. Okay.
I think penalties are penalties and need to be exact and economic penalties. So I always count 1,000 for each violation. I just think that if this board finds that you violated our law or rules, that there should be a noticeable penalty for that, not just a cost of doing business type of thing. Well, I got away with it, it cost me $250. I don't like that.
Right. I agree. I don't either. I think it needs to have some economic impact on the individual.
Well, I mean, that's what it says.
Penalty.
Yeah.
In some cases, the penalty is high enough to remove any economic benefit they got from it.
Yes.
You don't gain by breaking the rules.
Right.
And I agree with that. And the penalty needs to be such that, I don't ever want to do this again.
A deterrent.
As a deterrent, that's exactly it.
And when it's published, if they accept it, it's a deterrent for everybody else because they're going to read it.
Right.
Yep.
You got a number on your mind, then, Gail?
Well, I don't know, maybe it is this thing, and I don't know what size of track we're dealing with and what kind of gain we may have gotten out of this. What owed to us here, size of the survey was.
How big it was? How big the parcel was?
Yeah. Sure. The only reason I ask that is because as a surveyor, I give a couple of prices. I either give them by the foot or by the acre. And some not maybe by the job, but still, obviously the larger it is, the more the one individual gains on this.
Allegation that the respondent survey was less than the stated 70 acres. So we started out at least with 70 acres.
Pretty good sized parcel.
The survey had 2 errors that were causing the acres to be overstated, which resulted in an overpayment of $50,000.
Overpayment of how much?
$50,000.
Per acre price.
So, lots of land there, probably a farm or something.
Yep.
They're harvesting timber off
I'm
of
just
it.
gonna say probably 1,000 for each occurrence. I may be wrong.
For each rule,
For each rule.
because we got 2 rules, I did.
2 rules.
Yeah.
That's 2 green.
Am I too, well, that's the part we go through the scope of the house.
Well, I mean, you can say 1, 2, 3, and 4 is each a separate one too.
Well, I know,
But that's what you're trying to kind of
Yeah.
avoid hanging a
Right.
price tag on
Right.
each.
yeah, I don't think that we want to go to.
Yeah,
each
we don't want to go
individual
through here
one,
and put a tag on every right north and put a count on come there.
but I don't know.
They do that in the insurance business, don't they, Sue? What do you think, Sue? We're still in discussion.
There we go.
Okay, well, if we don't have any further discussion, Mr. Gale, if you make that in the form of a motion.
I'll make a motion that the civil penalty be $1,000 per violation of each rule that has been violated. 2 rules violated, $2,000.
You have a second?
Sounds
Okay, we have a motion and a second. If there's any further discussion, if not, all those in favor say aye.
Aye.
Okay.
Can I assume that you're authorizing a formal hearing, issuing the consent order? If they don't accept it, then it's going to, you already
Yes.
accept the fact that it's going to go.
Yeah.
That's their next recourse.
Yes.
All approved. Okay. All right, the next one. Same guy looked at this one. 2012-004281. This case was generated by the board's administrative staff and referred to a contracted complaint reviewer for analysis. Because of the allegation of incompetence in the respondent's professional practice of land surveying and possible violation of 62-18-116, specifically the allegations that the respondent produced a plat that's inconsistent with 2 previous plats previously on the same parcel of land by using a completely different set of calls. There's no previous complaint history for this respondent. The information contained in the complaint describes 4 changes representing corrected errors from the respondent's first prepared plat. The respondent admits that these errors were made and corrected them in later documentation. They include a new bearing on the north line, a new bearing and distance on the east line, a new distance on the south line, with a new corner established directly on the south line. The 4th alleged error, the north line falling outside the original survey line B, seems to have created a possible overlap of property, and the land description contains no mention of resolution of this line. Overall, there doesn't seem to be anything in the complaint that indicates gross incompetence or a lack of willingness to correct any errors that are or were discovered. So I recommend close with the letter of warning on this one.
Okay, we have any discussion?
I guess I feel like I don't know enough on this one to want to discuss. That's the worst thing about it. I really don't know where to go in the discussion on this one. I'd like to discuss, but I don't see enough here that I can discuss it.
Well, the reason I came to that conclusion is because this guy corrected the mistakes. They apparently weren't that bad, and nobody has complained about it.
I guess maybe that's a good reason to come to that.
Usually you know something's wrong when people start screaming, and nobody has, so.
Yeah.
Well, the strange thing is, it says he produced 2 previous plans, and this is the 3rd one that actually corrected the 2 previous ones.
Evidently, this last one, this is the one that got filed.
Probably the letter of warning is sufficient in this case. But I don't know what.
Now, this guy's got a real high license number, which means he's pretty new.
Okay.
He's not one of the old timers, so. No, I'm not talking about y'all at all.
Well, I think if you give him a warning and no penalty, I don't know that, he made the corrections. Even though it may have taken him a couple of times to realize, oh, I have really messed up here. I think the complaint probably is justified to say, start watching your work a little more carefully, but to impose a monetary penalty, economic penalty on him, just because, he made a couple of errors here and then he finally realized, oh, I should have done this. I think a letter of warning is sufficient on this. Nobody has been damaged.
Right.
And nobody's had to apparently go to court over the situation. And so
I should have put a list of mitigators on here. I don't know why I forgot to, but that's why.
okay.
Nobody's upset. He corrected them and he's new.
Yep.
So
And just let this be a lesson learned. As one said, what we learned from this little grasshoppers, be a little bit more thorough and pay attention to your work when you start out and catch what you're doing. And if you have handed off something to a client that is an error, call him right then and say, hey, don't do anything with the plan other than look at it, and I'll tell you what I found, and let this guy learn from his experience.
I think he's probably trying to build a practice, and I hate to fall on him like an old building right out of the barn, That's kind of a deterrent.
Anyway,
He probably won't do it again.
let's say this, if it comes back another time,
It'll be
that
worse.
way you'll have to open our eyes a little bit wider on this thing.
Is there any further discussion? If not, Chair will entertain a motion.
I make a motion that we issue the letter of warning to this respondent.
Do we have a second? All those in favor?
Aye.
Next case.
Okay, we're going to start our new ones here. There's only 3 of them. Number 1 is 2012-008211. Complaint alleges professional misconduct on the part of the respondent, possible violation of 6218-116. The complainant alleges the respondent participated in the acquisition of land adjoining the complainant's property in violation of a criminal statute that prohibits the transfer of property when the transferor has no legal or equitable interest in the property conveyed. Notice that's not in our body of law. The respondent was then seen trespassing upon the complainant's land and cutting a lock from the gate to the pasture where the complainant had several head of cattle. The complainant later found a dead cow in the vicinity of the gate. The identity of the observer of this trespass is not specified in the complaint or what particularly happened to the cattle. Okay, recommendation is the facts of this case seem to lay outside the jurisdiction of the board and fail to properly state an allegation that would constitute grounds for discipline, so I suggest that we dismiss this case. I didn't see anything that even remotely had anything to do with the practice of land surveying.
Well, it sounds like that that's going to go to some type of court of proper jurisdiction, and if that court does something that, for example, if you find out that the guy's a felony, it's a felony, then we got to do something with it. But I think that we have to wait and see what the court's going to do, if it does go there.
Okay, well, we can close it instead of dismiss.
Yeah, I'd rather not dismiss it because I'm thinking that if the court did something, if the respondent had any responsibility for the dead cow, there's a distinct possibility that we might be revisiting it.
Trespass to chattels, is what that's called.
So,
Cow.
we have any other discussion? Do we have a motion to close the case? Second? Those in favor? Okay.
Okay, number 2, 2012-008-931. I think this one's an easy one. The complaint alleges professional misconduct on the part of the respondent in possible violation 62-18-116. The complainant alleges the respondent improperly prepared a deed as part of the development project, thus contributing in part to a boundary dispute. There are no previous complaints, and the respondent is dead as of June 25th, 2011. This guy has a very low license number. So,
Well, I don't think we
been
can.
in it a while.
I don't think we want to be known for sending penalties to the deceased, do we?
Well, I would think that he's probably was older than most and has come on to his reward. I don't think the license transfers, so.
I move we dismiss the case.
Do we have a second? Okay, those in favor? Okay. Next one.
Okay, the last one. 2012-008-931. This complaint alleges professional misconduct in violation 62-18-116. The complainant alleges the respondent failed to properly pay him for 3 subcontracted projects, all in Virginia. Although the complainant decided to file a complaint with the board because a business transaction took place in Tennessee. Let me say that both the complainant and the respondent are licensees. The complainant was subcontracting to the respondent. The complaint file contains materials from both parties that describe a disputed business transaction, do not address any matters related to professional conduct. So there's no mention of anything that they did professionally as part of a conflict. It appears from the correspondence included in the file that a civil suit is either in progress, will be initiated in the immediate future to settle the respective financial obligations. Okay, the recommendation is dismiss the case due to lack of grounds for discipline because we don't really regulate business practices.
Well, yes,
They contract with each
all this
other.
work took place in Virginia. So obviously the guy's licensed in Virginia,
Yes.
or else he's unlicensed, and what have you. But I think if it's in Virginia, just because his office is here, they can file a complaint. But I don't think that would fall under our jurisdiction.
Yeah, there's a couple of reasons why we probably shouldn't address it. And that's one of them. The others that we try not to get into people's business
Yeah.
transactions.
I move to dismiss.
All those in favor?
Aye.
That concludes the legal report, Ron.
Yes, sir.
The issue that I sent you an email on, is that something we can discuss later?
Yes.
Okay. Okay. The next item on the agenda is the director's report. And I'll turn that over to Ms. Moulton.
Okay. Well, just a few things, minor issues that our office is experiencing with statutory right now, but we've been interviewing. Hopefully we'll have somebody here by the end of the month anyway. Laws for land surveyors regarding the FS exam fees and the provision amended, prepare for NCAA's conversion to CBT testing, or CBT for the FS exam in January 2014. We've already discussed that.
Right, we have an item on the agenda. We'll talk about that
Right.
a little bit later.
Below that is just got some little budget information. The end of fiscal year 2010, 2011, we have an adjusted balance of 85,681. The end of May 2012, we have a balance of 23,582.55 because that was a renewal year. 2011 was a renewal year.
This is why we need staggered renewals. It's a feast or famine.
But thankfully we're not either.
Yeah, that's good.
Yeah. The next section section is our complaints. We've got 21 complaints, 18 have been on time. Percentage of the on-time complaints are 8,000. Robert could probably explain that more than I could.
Well, the target, as you can see, percent on time is 85.71, the target 75, so we're doing good on our complaints. The oldest one that we have is the one that we talked about this morning with Jesse. So we're handling our complaints pretty well.
What are the three, it says that we have 3 with clock stopping action.
I didn't know we had 3 like that. Well, whenever we get a case in, it goes to the staff. The staff sends out a letter, I think it's 15 days or something, to get the responses, and then it's referred to legal. When it's referred to legal, another 180 days starts.
Okay.
When I look at it and decide to send it to investigations, that's another code, another 180 days starts.
And this was as of July 9th, so that, you know.
I get it, I present it to you, and I present it to you, that's another 180 days, consent order approved or whatever. Goes to litigation, clock stops, another 180 days goes. So apparently we got 3 without something that changes the code.
That may change everything.
Yeah, probably, because that one Jesse has is been in litigation.
Yeah, it had been since 07, yeah, so it was real old.
Yeah.
It's over 180 days.
Yeah, definitely.
It's-
That's probably the oldest one we had, I guess, wasn't it?
Yes, it is.
But we still have 18, and I assume of that 18, we took care of some of them here a while ago.
Right.
4 or 5 of them. or whatever.
I suspect the other 2 are probably the ones that we reviewed. And one of them is still out. A third case reviewer has one that hadn't gotten back to us yet.
Okay.
And that doesn't count as clock stopping. There's no code for when we send it to those guys.
But anyway, we're above 85%, which everybody's happy with that.
We're over 75%. That's the target. So
And that's what we want to do. We want,
as far as the General Assembly is concerned, we're doing our job in a timely way. Apparently, we're in the green.
Must be the secretary.
And then just a little FYI, the activity report as of July 26, 2012, how many active surveyors, in-state surveyors, we have 816. We have 70 LSITs, 36 inactive surveyors, 27 retired, 326 active out-of-state, and expired as of 7/26.
that was just this year expired, right?
Right. They expired December 31st, 2011. We have a total of 55. And about half of those, about 30 of them decided not to renew at all, so. And then there's just a little graph of, those numbers.
Yeah, I like the graph.
It's colorful.
I mean, it's interesting to note that since 05, 06, we now have less surveyors. And I don't know if a lot of that, the last 2 or 3 years, has been economic related or not, because we've seen an awful lot of non-renewals.
It
Yeah.
costs money to maintain a license.
Yeah, I know, it probably does have to do.
You gotta have errors and omissions insurance. You can file and see.
Yeah, that little bottom chart down there, that shows that crazy expenditure we're talking about.
Yeah. Every odd year, you'll see it's real low.
It'd be
I mean,
nice if
every
it was
year.
more level across there.
And every odd
Yeah, I
year
think it'd be
it's-
easier to budget and everything else.
Yeah.
Yeah, that's just ridiculous.
And you actually send $5 of each licensee's fee to the general fund or something?
They
or-
take it.
Oh, okay.
Everybody's, not just ours, but everybody.
Okay. So every license in the state
Every
pays $5.
licensee.
Okay.
Would it, while we're just talking about this, just for a general comment, would it be beneficial, well, I know it would be beneficial to us, but what would be involved in going to a system where we renewed, by alphabet or by
Well, that's what we're
birthday or by
talking
what have you?
Next thing.
And I knew that we want to do, but I'm just saying, the benefit would be that we would have
We'd have
a constant
Right.
even amount of money in the budget.
Right.
Well,
rather than up and down and up and down.
and we looked at a different report in greater detail here a couple of years ago or whatever, but at that time we talked about it was, you know, I don't know how they really budget because you don't get any level of consistency. And then the other thing is, one of the charges that we're responsible for as a board is to make sure that we stay in the black. And if we can anticipate, if we have this more level revenue expenditure chart, then if we can anticipate that, you know, year after next or whatever, we're going to have a shortfall, we may have to increase what the license fee is or whatever. So we can predict that better. But right now, I think it's very difficult for us.
And another thing, for the CBT testing, we're gonna lose that FS
Yeah.
money right there, and that's on the whole great lot.
Out of the, just while we're talking about, out of the FS, how much money do we actually get out of that fee? Because you see, they charge for the test booklet, and then they charge for the scoring.
Yeah, we charge for the one test, we charge $125.
Right.
I'll have to go look, I don't know exactly. I mean, I'll have to go look at a bill and see if they charge to score them. I don't remember exactly how much they charge. But I can go look at lunchtime.
So we may have to put a fee as part of the application, the FS, in order to maintain that margin that we've been maintaining after the other fees.
Well, let me ask this question. I know that Pete Reagan always came back shaking his head and saying, well, because of budgetary constraints and because the department decided to take our funds and put them in the general fund, and now we don't have those to operate with, and what have you. And I guess my question is this: on the year that we renew, and we have a large sum of money to operate with, what is the possibility that the department would come and say, hey, you all have a pretty large sum of funds here, and we're going to take it and put it in the General Assembly, whereas if we went to, alphabetical renewal, that fund would always kind of stay level.
Yeah, well, when they decide to do that, they don't just take it from us, they take it from everybody. And I don't know what constitutes them taking it like that.
Well, I don't either.
Last time that I remember being done was, gosh, it's been a while.
Just like the engineering board, they have taken advantage of some of their surplus by giving grants to like UT and Vanderbilt, wherever,
But we don't have that kind of
for their engineering departments. But that's because they build a surplus, because their numbers are so large.
Yeah.
Well, and I can understand that, but I would say this, and I want to say this because I was looking at these figures and I looked at that large number and didn't put two and two together here, but I thought, we talked about the Blue Book, and if we had that kind of funds, I would say I would like to see us put money in the Blue Book and send the surveyors a 2013 or 12 version of the Blue Book and say, don't say you didn't get it. And we start periodically having ethics training. I'm just saying that it might be beneficial. We'll have to take a look and see what the budget number, but I wouldn't want, the department to come here and say, oh, well, we're taking from everybody, and then they take our Blue Book money.
Yeah.
That kind of thing.
And I don't even know if they let us print this anymore.
They may
Because
not.
the internet.
Once again, we put it on our wish list, please.
And it's not
Change
just
it.
us, it's everybody.
In the engineer's law, it says certificates of registration shall expire 2 years following the date of their issuance or renewal.
Here's what I think.
2 years after, doesn't matter when you get it.
And it wouldn't bother me if everybody expired on December 31st. Keep that date. But like A through M expired odd years. The rest of them expired even years. That'd be fine with me. Y'all want to do it, I don't care.
That's basically what Kentucky does.
Yeah.
And that'd be fine. I don't have a problem with doing that, as long as it would keep our funds basically level.
Yeah.
Because you're up and down, and with this CBT getting ready to come in here, we don't know what the expenditures are going to be, but we're going to have to still stay in the black.
Because you see, not only do we face the potential fall of revenue on the FS, we're going to face it within probably by 2015 on the PS. because they're coming pretty quick with this.
And then we may have to increase our registration fee, because it's only $100.
How long has it been?
Since it's always been on, forever and a day,
So 1860.
as long as I can remember.
It's
Well, that's-
going to have some increase.
Yeah, that's the registration fee for the new licensee.
Right, right.
Right.
It costs us that much to cost us.
Here's what it used to be. When I first started in 95, the exam fee was $100. If you took one exam, you took 3 exams. If you took it once or if you took it 500 times, you paid $100 each time you took it. Then when you passed it, you paid $100. Application fee was $150. Now, I don't remember what year that we increased it. But then we went up to $200 application fee, $425 for exam, you took all 3 parts. They broke those exams down by exam and started. Registration fee, $100. Registration fee has never changed as far as I can remember.
General Assembly, it's raising fees. And everything else.
And the only reason we raised them then was because we were in the red zone.
Wait a minute, I didn't mean to get sidetracked.
That's fine.
That's what we do here, is talk about the profession.
Right.
And it's all in my,
I think we got time to look at this.
Well, we have the legislative changes also.
Yeah.
And we made that
that's
agenda item,
That's
so.
right. You need to
uh,
be agenda.
If we can, before lunch, if we can just look at these rules that we're trying to get started, so you can approve whatever changes.
We will forego the legislative changes discussion in order to look at the rules. We'll come back and catch those after lunch.
So I think we can get this done.
We're going to move on. We're going to skip the very end of Donna's report. Yes, sir. And we'll come back to that. So we can go ahead and accommodate Rob.
I really want to get started on these
Okay.
conduct rules.
Go right ahead.
I've talked to, and I think if I remember, some of this stuff, at least some of it comes from the model rules.
That's correct.
But I want our rules to be effective, and as less complicated as possible, and to remove whatever redundancy or whatever might be in there. And I was talking to some other attorneys about this too, just to see if we can, people like Jesse and me, to see, if we ever did have to pursue a disciplinary action based on something, how easy or difficult it would be, or if it was possible at all. So anyway, made some notes here. So the first note I made was on Rule 1, applicability. Now, it looks like we put this rule in the notice of rulemaking hearing, but we're not doing anything to it. We're not adding or subtracting. And typically, we can't just open a rule and do nothing to it. So I think we should probably take that out until we're ready to actually amend it in some way, unless you have an idea of how you want to amend it.
I think we need an opportunity to sit down and talk about this a little bit more. I don't have an idea how I'd like to do this right now.
Well, I don't remember why if we don't have an idea of what we want to do, we should probably wait until we have the feel.
Yeah.
So-
As Tim has, he may have
No, I think that.
put up midnight oil here.
No, I think that what we did was, my secretary has been helping me with making sure we have the current revised information and so forth. And what we did was, I had asked Donna, I think it was, to get a Word document of this particular rule, and that is part of the original rule, the current rule, the
Yeah.
current standing rule.
Yeah.
And therefore it was just placed in this document. And Rob's right, we're not touching it, so we certainly can eliminate it. I don't have any problem with that, but that's the source of it. All it is was just a copy of the original, so we could start making changes and so
Yeah.
forth.
And that's
So if
fine.
we need to delete it, I had no problem with that.
Okay, at the end of these suggestions, if y'all can just vote
Sure.
on what we're talking about, and then I'll amend our notice, and I can send it up to the pipeline again and get it filed as soon as possible. Yeah, it's yours. Okay, the second rule is number 2. On the proper conduct of practice, and in paragraph 3, we have timely response to all correspondence from the board, not really saying what timely is. So I think maybe we should replace timely with within 15 working days or something. Because timely doesn't have a definition of the way it's written.
It's not me.
15 days, 30 days.
15 okay?
Yeah, 15 probably is sufficient.
Okay.
Well, 15 working days ends up being almost a month.
It's almost
a month.
Yeah, I mean, you're talking about 3 weeks right there.
Uncertified materials, we know when they got it.
Right.
That's right.
On stuff that we just mail out without certification, we don't know when they got
Okay,
it.
well, that's fine.
Okay, so we'll change to 15 days. Otherwise, the phone will ring and somebody will say, "What does timely mean? Or why are you disciplining me for this?" I don't know. You know. Okay, the next one is in the paragraph 4, which is a new one. We're prohibiting our registrants from assisting an applicant that the registrant knows isn't qualified. Okay, I think we probably need to define assist a little more. And probably should just delete character, because that's going to be really, that's really subjective. Education, training, and experience, I think should really be all that we need to think about. But what do you mean by assist? Is that
Well, that goes back to, I think, what Mr. Campbell spoke about earlier, is whether you're mentoring or just thanking somebody at work. That would be my definition of assist.
assisting an applicant that you know is not qualified? So a registrant is assisting a person that they know shouldn't be a surveyor to get a survey license.
Right.
So assist is, should we say assist in any way? And that means that he didn't have anything to do with it.
That's fine.
That means no writing letters, no making phone calls, no nothing.
In any way, the application for licensure, that's fine.
I think that might be more descriptive of what we're thinking about. And the next one is rule number 3. In the new paragraph 6, we're requesting the registrants to notify the employer, client, or other relevant party when their professional judgment is overruled. This sounds like it came out of the model rules.
It is.
I think that's right.
Okay, I think we might need to change it to something like when they're being required to provide services in violation of the board's law and rules, since that's what the law and rules do anyway. Because nobody can tell you or make you violate the law and rules. Or we can just delete it, because you're never, ever allowed to violate the law and rules anyway. It doesn't matter who you tell or don't tell. We're having a little trouble with professional judgment is overruled, and I got a question like, overruled by who? And I'm thinking what that's supposed to indicate is that you are told to do something that you know violates your professional judgment. And by inference, you would mean violation of the law and rules, which you can't do anyway. It just seems a little redundant. If you tell your boss, I'm not going to do this because it violates the standard of practice, and the boss, you got to do it or you're fired.
You prefer to leave?
I think so. Because you can't violate law and rules no matter what.
I don't know.
Because of how kind of strange it sounds,
That's
or
fine. That's fine.
we're probably better off.
To leave. No problem.
Right, number public statements is the next one. New paragraph 4.
Which one now? Paragraph
Which
4?
rule?
Rule 4.
Rule 4, new paragraph 4.
New paragraph 4, okay.
Now this is the one about making statements, criticisms, arguments, which are inspired or paid for by interested parties. Now upon reflecting on this and reading it and talking to other attorneys, that's sort of the definition of an expert witness in a lawsuit, where the attorney does pay you to provide professional testimony in support of their case. So I don't really think we need to have that in there, because in the interest of clarity, it's probably not really needed. You know, opining about technical matters which are inspired or paid for by interested parties. That whole thing is exactly what an expert witness would be.
But it could still be a third party being paid by someone.
To make a statement.
I don't know why somebody would, but potentially it could be.
Either, but still.
I can't devise a scenario where that would be.
That's fine. You want to delete it?
Well, yeah, I kind of think
Okay.
that that's what an
We'll
expert
delete it.
witness is.
All right.
Okay, I think paragraph 5 is the next one. The one right below it that's new. Prohibiting registrants from defaming fellow registrants' character or professional reputation, either through slander, which is spoken, or libel, which is written. Both of them have to do with defamation of character. Now, it's not really our responsibility to determine that kind of thing, because the only way to really enforce this is if somebody comes to us with a judgment from a court, a ruling that says this person defamed me and injured me and I recovered damages because of it. For us to sit here and try to figure out what defamation is problematic. I mean, and there's other remedies available if you feel like you've been defamed. It'd just be a little tough to enforce just on that basis. And once again, it looks like it's NCAA model rules. Conflicts of interest, number 5. We've got a new paragraph 6. This is the one that talks about conflicts of interest because your employer sits on the board, or some other government agency that's responsible for awarding contracts. Now, this type of activity is already addressed in another code, which specifically is Title 12, Public Property Printing and Contracts, Chapter 4, Public Contracts. That's our state law that has to do with exactly this kind of thing. So we already have a body of law that prohibits that kind of activity anyway.
And you're speaking to paragraph 6. Okay.
That's in another body of law on who and who can't contract with the government. In great detail, I might add.
Okay, I'll delete it.
Let me ask a question before we decide to delete that. The surveyor is not, without going to Tennessee Code Annotated, he wouldn't know where that is, he wouldn't know anything about that. The only thing he can say is, well, should I or should not? And if they, even though it is under another body of law, it might not be bad to leave that so that he reads and he knows, all right, if you want to put a, you know, if this is covered, this type of thing is covered under whatever, and just give a reference to whatever that other body of law is.
Well,
what would be wrong in doing that, or what would that either benefit or not benefit us?
well, this is what was sort of in my mind about it. Surveying seems to have an abnormally abundant contact with the government as far as TVA and TVIC. I mean, there's a lot of state land out there.
Yeah.
And most surveyors know it, and they also know if one of their employers is on a governmental body. So they already sort of understand that there's certain things you got to do in contract with the government. So it'd be hard for them to say they didn't know that there's restrictions on it. If they have a question about whether or not their company should contract with the government, they should probably contact that appropriate governmental agency.
Okay.
Making it a disciplinary offense under our licensing rules, we would need a whole lot of proof of a whole lot of things to prove that conflict. There would have to be something going on elsewhere, and that means that people would file complaints with whatever agency that is, if they were cut out, and there's an unfair advantage.
I guess the key answer to your question, Gavin, is if Rob finds it, the AG will find it, they're going to keep it anyway. Fair enough.
You can't contract with the government without being highly scrutinized. Yeah, but,
You're also saying you probably were at 7 too, right?
well, 7?
Yeah. Paragraph 7 in the same section.
I don't have a paragraph 7. Which one was that?
I got 7 on there.
I got 7 on it.
Yeah.
It's not on my pad.
It's actually 6 on the document here. Let's see.
7.
I got 05 and 06 and 08.
I think it's got the same thing.
Paragraph 7.
Yeah, I had 7 in my draft.
7 in mine.
Yeah. And that was the last draft that I had was 213.
I put the one you said.
Well, the number 6 that's on the little thing here, whatever this thing's called, iPad, whatever it is the same as the number 7 that I have here. And the number,
Some strange way. of
okay, there's a
listing
number
mine.
5. The number 5 that we have in the printed copy is not on this one here, on the iPad.
Okay. Well, anyone that has to do with,
So you want to get strike what's on the iPad, what is 5 and 6 is there, it's actually 6 and 7.
It's got 6, but if it doesn't have 7, it just stops at 6.
No, only my iPad had 5 and 6 on my iPad
That's
is
right.
equivalent to 6 and 7 on my paper.
I think that's right.
well, the one that deals with contracting with the government
Yeah.
has to be taken out.
Okay.
Okay, acceptance of work, paragraph 4. Next one down. That's a reciprocal of what we talked about with defamation. So I think we should take that one out too. Slandering your fellow folks. Okay, the last comment.
Now, let me ask you this question. If we take that paragraph out of that section, then that rule is not changing. We have to eliminate the entire rule based on your discussion from before. Is that not correct?
Yep, we can eliminate the entire proposed rule.
Because rule 820.04-106 would have no change in it, so we have to eliminate the entire thing to be consistent with what you did earlier.
You are correct. All right, seals.
Got one right.
I think paragraph 8.
They want to work out everything you do.
You write that one, don't
What did you come up with?
you? Rule 6, the entire rule will be struck on the new document because we're not making any changes.
Except one, rule 6, acceptance of work. It's going to stay as is.
It's saying it is, so we just strike the whole thing.
We just say the whole thing.
Okay.
Okay, the last one is paragraph 8, new paragraph 8 under seals.
Yeah, I need to talk about that. Go ahead.
It reminds me of the old days when you used to have to take out your pencil and cloud things and put a delta symbol. Well, the question came from people that aren't technically minded. They didn't understand what that really meant. So I suggest that we clarify that to determine that revisions must be identified on the drawing, either by clouding, identifying number, or otherwise.
Where are you wanting to do this at?
In that same paragraph. Just expand it to say the rule,
On paragraph 2,
paragraph 8,
oh, 8,
under seals.
oh, 8 under C. I'm sorry.
Just expand it to say the revision must be identified on the drawing either by clouding with an identifying number or otherwise, and properly recording the revisions in the appropriate revision area of the document. That kind of describes,
And also sign and seal with the register of responsible charge.
yeah.
I'll have to get that language.
If
right.
it's
That
a
was
different-
Too much for me to write.
Okay, well, let's see
That's
here.
fine.
Any revision to a document containing the seal and signature of a registrant should be described and dated. Okay, and then the second sentence we're going to leave alone. But the first sentence I'd like to expand to say, any revision to a document containing the seal and signature of a registrant shall be clouded with an identifying number or otherwise, and properly described in the revisions area of the document. Because they always have a little clouded, you put a delta number, and then down here there's a number that says,
Yeah.
just to expand that to, because people didn't understand what described and dated.
Okay.
I don't have a problem with that.
You know, I know what it's talking about because I've done it before. I'm sure you have too. But write it for the common man. And that is really all I had.
One thing we need to do, I think, Rob, is in our current rule, once we get to the part that says seals, we have a picture of the seal. That needs to be included. I don't know how to include that, Mr. Haft. I'm not real swift
I
about
don't
that.
either.
That needs to be included, and I wonder out loud if we need to speak to a dimensioning of that seal. In other words, is it okay if the seal is the size of a quarter, or is it okay it's the size of the bottom of a 5-gallon bucket?
Let's go.
That'd be a good idea. Because I have people call and say, what's all this have to do?
Yeah, that question is asked a lot to me.
Yeah.
And there's two issues there. One is the size of it, and two is if you go back to when our law was changed to allow for the BS degree, it stipulates that at that point in time we are professional land surveyors. And our stamp says that we are registered land surveyors. I think this is a very opportune time to become a professional land surveyor, which is what we are striving for constantly. I think we need to include the stamp in the document, but I think maybe I could do that with PDF or something to get it in there, cut and paste or something like that. And I think I would like to recommend that we make the change from the word registered to professional. And then I'd also like to recommend that we speak to the stamp of having a size of 2 inches is what sticks in my mind.
Let's go back to paragraph 2 under seals then, and we can add another sentence.
One that has been lined out up there, the register shall stamp the seal. Is that what you're talking about?
Yeah, now we have a new, we wrote that to what you see there underlined. So
Right.
you get to the implementation period. Let's add another sentence, the seal shall appear as, I think that's a good place to put it.
I was going to look right here. I think I brought George's. One of them that I had on all the time. I think I did some checking, and I think I came up with a 2-inch diameter.
That's what I was thinking.
Okay, the seal shall be,
That's on the education.
And we're going to say
the size of the seal should be 2 inches in diameter.
that that will be a standard size no matter what document you put out,
Right.
whether it's an 8.5 by 11, 8.5 by 14, 18 by 24, it'll still be all that same size.
Size of the seal shall be no more or no less, or exactly, or just shall be 2 inches in diameter.
I'll tell you what, maybe I just replaced one of my stamps with an auto inking stamp, and I don't remember what, I've got it in the truck.
Or no less, or just say 2
And
inches.
when we go for lunch, maybe I can go down and get it. Let's just kind of measure that and see, because if we say it's exactly this or that, because we got, I mean, folks that are scanning their stamp in and they're scaling it proportionate to the size of the drawing.
Right.
I think that if we're going to require that the stamp be a particular size, that it stay that size, regardless of what size of drawing it is. So maybe I'll bring that up here because I've got it, and we'll kind of see. But when they order the stamps, that's what they're getting.
Yeah.
And I have no control over what they're doing unless we specify that each stamp has to be, yeah, there you go, something similar to that right there.
Yeah.
So,
I think you'll find that it is.
That looks,
somewhere in the neighborhood.
Yeah.
that looks exactly like the size of an engineer's work.
And that let it measure it.
I don't know if,
Scale on it.
I don't know if does their statute specify a size in theirs?
Not the statute, it probably does in the rule.
Or their rule rather than I said statute, I could know. If their rule does, maybe we could, at lunch you can find the wording and maybe we use their wording to be parallel.
The scale 1 to 100.
Well, it's 1 and 8/10.
Might get 2 inches.
2 inches.
2 inches would probably fit it.
It fits within 2 inches.
I would think that the stamp itself, on the self-inking thing, and I'll bring it up, fits within a 2-inch diameter. And as long as it does that, you don't want it any less than whatever we are currently getting, but not any larger than that.
If it was any smaller, you wouldn't be able to read it very clearly.
Yeah, that's the whole point. When they scale those things down, they're really, difficult to read.
If it was any bigger, it'd be ridiculous looking.
And just simply say something irrespective of scale or size of document. After we say, well, how big it is.
Yeah. I think so, don't you?
Yeah.
I think we could go ahead
And
and
what
say
that
2
does
inches.
two things. That protects the surveyor because somebody is going to reproduce a document, and if they reduce or enlarge the size of the document, the stamp's going to be enlarged or reduced proportionately when they put that on the scanner.
Right.
The surveyor, when he does his document, he stamps it, whether it's an elevation certificate or whether it's a plat, it's always going to be constant, whatever that may be.
Okay, you want to hear what this is what I think. The size of the seal shall be 2 inches in diameter in all cases and on all documents regardless of the document size.
Sounds lovely to me.
You got to cram it in there somewhere, it doesn't matter what. 8.5 by 11.
Just to repeat that last part, in all cases, regardless of the document size.
Yeah, or size of the document. I think that might make it clear, regardless of the size of the document.
I'll need to get that other language from you, that way I can get this document changed then.
The size of the seal shall be 2 inches in diameter in all cases and on all documents regardless of the size of the document.
Let me tell you, I had an engineer file a complaint against me because I didn't put the date on it. I'll tell you that if I take a document and I stamp it with my stamp, and it's 1.8 inches, some engineer lays it, and I'm just saying because it was an engineer, he didn't know me from Adam, but if he did that, he was on a witch hunt. But, what can I say? If it comes in, it's 1.8 inches, oh, you're not not following standard of practice, I'm going to say that we as a board are going to have to say, yes, he's following that. 1.8, I can't help the manufacturer, but we're going to say that that's what we want.
If you use an electronic representation, it can be exactly 2 inches, but if it's a rubber stamp,
Yeah.
it's close enough.
I haven't gone to the electronic.
I don't know if we ever will. It'll probably appear something else.
Okay, are we good at the moment, Rob?
Yeah, I think if y'all want to vote to accept
Okay,
these
yeah, we
changes,
need to
then
do
I'll,
that.
then I'll change the notice and get it out of here.
Sue thinks it looks good, she's going to make the motion.
Make a motion that we adopt the changes. I agree on all of it.
Second.
All right, we have a motion and a second. Do all those in favor say aye? Aye. Okay, it is approved, Rob. So, Ms. Donna, we will now adjourn for lunch and reconvene at 1 o'clock.
How do we turn it off?
Hold it down.
Well, you-
That was the first, yeah.
Okay, it's now 1:23 p.m. We'll reconvene the Board of Examiners meeting. Mr. Northcott's over in the corner cooling off. What did you decide about the diameter of your stamp there, Mr. Court?
I brought it in, but I haven't taken it out. Please feel free to take it out, stamp it on anything that's worth stamping.
Too hot.
Got any official documents over we can do this on? Well, we'll do that in a minute. Okay, the next item on our agenda, I want to go back to the director's report. Let me get this thing to move here. Man, I'm trying around, it don't like me or something. Aha. At the end of the director's report, we forego this so Rob could talk about the rules of conduct. We could get those cleaned up a little bit. It says discuss legislative changes. There's 2 or 3 things in there that says that we need to clean up or remove or deal with.
And that's just suggestions, guys.
Right. You got more? That's good.
If y'all have some, go ahead.
The one I wanted to focus on initially was 6218-113, which is expiration date of certificates. I feel like it'd be prudent for our board to pass a motion to empower Donna to do whatever's necessary through the interdepartmental legislative process or whatever. I guess it's our old wish list.
Yeah, Robert's.
Okay, or Rob to do it, in order to try to get our renewals on some type of annual basis so that we can kind of have a consistent income and expenditure reports and really can see where our budgets actually stand. And whether that's done by 2 years from when you were licensed or alphabetically or divide the number of licensees in half or whatever it is, come up with a method in order to do that so that we can kind of alleviate what I feel like is a little bit of a problem the way we currently do it.
Yeah, I think we should probably just duplicate one of our closest boards, closest favors, engineers, that expires 2 years after the date of their issuance, which makes it sound like a rolling registration. They get their license 2 years later on an individual basis. I don't know what the rules say about that. But if we got the statute changed to say this, then we could write a rule about more specifically about how we want to renew. As long as it's just not every 2 years.
Right.
Right.
A&E board, they've got a pretty consistent flow of revenue because of how they do it. What's the board's opinion? Every 2 years from the date of issuance or renewal, no matter when you get it?
Well,
In other words, like mine was issued in, April of '87. Is that what you're talking about, that date of issuance? And then
Yeah, every 2 Aprils
every
for years.
an odd year, whatever that may be.
Now, what,
Because he might have got his in an even year.
what the law, the Board of Professional Responsibility has changed just now is you renew on your birthday.
Yeah.
It used to be everybody expired on March 31st. And now it's your birthday is when you're due. I don't know why they did that. They didn't say that, but it sounds like if everybody expires at the same time every year, they had a kind of a problem, like, or at least a bookkeeping problem.
well, I can see a little bit of a bookkeeping problem for Donna trying to ascertain how difficult it is month and year for you.
How are you handling people that got their license and then 6 months later it expired? You know, they got their license in the year that everybody renewed, and only got part of the license. Is that prorated? Or?
No, because they haven't, like, if they got their license in April of 2011, they expired December 2011, they only paid $100 for their license.
Right.
And they'll pay the full renewal fee at the end of the year. So they're not prorated, they're not
Right,
out.
there's no proration.
No.
I mean, if you got your license in October, but you don't actually get it, if you actually could have gotten your license in October, right after the exam, you would only had it for like a month for $100, and you had to pay the full fee.
Yeah.
So that could happen.
Yeah.
This statute would prevent people paying full for just part of the license.
Yeah, if they get licensed, for example, if they got their license in January of 12 and it ended in December, then they pay the $100 when they get their license then, but do they pay the additional $140 to get to the next renewal?
They don't renew it again until 2013 and the rest of us.
Well, that's not right. But that's not right.
I know. I just said that.
Well, you know.
Yeah.
But I mean, they should, if they pay their $100, that $100 should only entitle them to end that 1 year.
So anybody in January 2012 should get a renewal notice for $140.
At the end of 2012 to get them on the cycle.
Right.
Would you not agree with
I
that?
agree with
But
it.
that's not, that's
But
not.
we haven't done that.
No.
We need to be doing that.
I think
But
that.
I can't. I
Because I don't think our statute says that just because you pass the test, that you get 2 free years.
No, and I don't know if it has to be in there that we do that. Does it?
You can't do anything you don't have authority.
'Cause I thought the $100
Odd
was,
year.
But yeah, December 31st of each odd numbered year.
Yeah, so they're not expired yet in 2012.
And it
the
doesn't-
$100 is only for the certificate of registration. That's actually for the plaque that we sign. That's all it's for.
I know.
It is not for their annual renewal. See, the annual renewal technically should be prorated from the time they actually get their license until it's up, until the period's up.
Kind of thought we were doing.
I don't think that we're doing it.
Because you're getting the partial license, and then getting the full 2 years, so you pay for
In other words, to
the
use that example,
use the partial.
if I received my license in January of 2012, and the renewal period ended December 31st of the prior year, then when I pay my $100, that gets me my wall plaque,
Right.
okay? But I owe an annual registration fee that would be for 23 months instead of 24 months to get me to December 31st of 2013. Because what you're doing is you're licensing somebody and then you're not charging them a fee.
Well, I've always kind of
Leave it to Tim.
That's what I'm.
Leave it to Tim, what Sue said.
I always kind of thought that was a big problem with trying to figure out that program.
No, you
So they had that all done.
Yeah. I thought we
My
were
license, they gave me a free 6 months.
Everybody figured it
I don't know
out.
how this goes
I
out.
don't think we're done.
Well, that's, the way our law is written right now. everybody expires at the same time. It just seems like you just pay for whatever piece you initially
But would it
had.
have to be in the law?
It is in the law. It doesn't say anything about when you get it. It just says they all expire.
On December 31st of each odd number of years. So
Right.
that's everybody
That's everything.
Correct, even
right.
people that got their license.
in 2012. So would it have to be in the law that says something about what we were just talking about?
No, I don't see why it would be.
They got
It just simply says that they all expire on the 31st, so you'd only pay for whatever
Portion, yeah.
harsh.
I don't think anybody would raise a stink about being prorated.
It's just.
So,
it's
all right,
just-
that's all right. Everybody
If
that's
you got your license, you gotta pay at the end of the year.
If you received your license this year in April, the way it's currently be done, you wouldn't pay until December 31st of 2013. But that's not right, because the $100 certificate of registration is just what it is. It says, hey, you've passed the test, send us $100, we're going to send you your little billfold card, we're going to send you your wall plaque. That's all that $100 is for.
They have to pay.
And then you've got to pay for the rest of that year, and the next year, if it's applicable, whatever's applicable to get that registration done, they've got to pay. So if they're not paying, we're not doing it right.
Right. So at the end of, everybody got their licenses in June, because they took the
Okay.
April exam.
Okay.
So at the end of December 2012, I got to send them every one of those.
Yeah, they will
$140.
they will not be licensed. They will not be licensed for 2013.
So how I got to go through RPS and all that to get that set up.
Yeah, it would be a pain. That's what I was wondering how you would do it. Because it's, everybody expires at the
Because
same time, no matter how long they've had their
according
license.
to our rules and statutes here, if you've not paid your fees, you're not a licensed surveyor. And if somebody could come in and prove this situation exists, then that individual would not be a licensed surveyor.
And when have you got your license in October? Still got to pay in December.
That's why the E&E statutes, it expires 2 years after your license.
And see, that way you don't,
There is no proration.
there's no proration. In other words, if you got it in June of this year, then 2 years later, you're going to pay.
Okay, so I'm going to go to RPS and get all this done.
That's why this statute would make it a lot simpler.
But you also have to bear in mind that in their statute, they're paying their annual renewal when they actually receive their license.
Seriously?
Yes, they have to be.
So like, if they, when they pass the exam, they pay, what is their fee, $140? Send them $140 to get your license.
John to come down and
Sure,
explain how they
that's
do it.
fine, yeah, sure, do that.
Because I think that.
Now, I didn't know that's how they did that.
Yeah, because if we're missing out on somebody, technically speaking, we're putting a hardship on the licensee.
See, I didn't know anything about this side, all this been done
Yeah.
since this law was changed, and went into effect in 2003, and we never questioned it.
See,
I didn't, Carol didn't, nobody.
there's not a great injustice if it's in the year of renewal. In other words, if it was in 11, in other words, if you got your license in June of 11 and the renewal came in December, it's not a grave injustice to have not applied a prorated renewal, even though it should have been.
You're talking
Yeah.
only 6 months.
You're talking only 6 months. So, but if you get it in June of 12, then you don't renew to the end of 13. That's 18 months. Now it's an injustice to the licensee, because technically speaking, even though your website would show that they are active, they really are not.
They really haven't paid.
They have not
Right.
paid.
Well, before we get into how we're going to do that, if we are going to make this change, and I think we need to do that, then it may be a moot point if we can make this change to however you would like to do it, whatever would be easier for you. If you take A through L and M through Z, every other year, or you do it by birthday, or however you want to do that. What that does is, obviously, we're looking to equalize the flow of revenue coming in.
Yeah.
And whether it's done alphabetically or done by birthday or whatever it may be. But there again, if the licensee, as he takes his exam and passes it, you know, he needs to pay from that point, once he has passed it, until the time that he
If he
reviews.
passes it in an even year, and he's an A that expires odd year,
Yeah.
he would have to pay. No, wait. If he passes it in an even year, okay, passes it 2012.
And that's the next time he's gonna pay against it.
The next time he pays is 2013.
Right now.
Right.
Right
Current
now.
system. But if we go to the engineer
All right,
system,
if we go to the SNF system, if they pass it in 13, would they pay for 13 and in 14, or would they pay and not pay again until?
again, the certificate of registration is only for that wallet card and that plaque, that's it.
Yeah.
Now, you're right.
If he passes it in 13, be it June or be it October, whatever it may be, whatever, or, you know, of course, if he passes it into 13, then obviously he's starting 14, whatever.
Yeah.
But there ought to be a prorated fee from June through December 31st if you're going to end the license period at the last day of December each year. Whether it's, like I said, whether it's A through M or whether it's his birthday or what have you. Of course, his birthday obviously would end at the end of the month of his birthday, and that's a nightmare to kind of keep up with too.
The only thing I wonder about theirs is, and John will answer it, is since we only give our exams in October and April, then that's when your heavy workload's gonna be. Or well, if we give them in October and April, then it's probably gonna be January and June.
Right.
Basically. That'll be when your heaviest workload will be, because most everybody's gonna taken the exam and got licensed pretty close to that month. I mean, you might have a few Mays, and you might have a few Februarys or whatever, or Decembers. But no, if we're doing it the other way, I think we're missing some fees on
I do too. I never really thought about it.
I mean,
Discussed it.
Yeah.
I do think we're missing out.
Like I say, just think of that certificate of registration is just strictly for the privilege of
That's all it
that plaque.
is for $100.
So I'm gonna have to go and get RBS all changed. That's what I can't figure out. That's no big deal.
Well, to get it set up, it'll take a nightmare of work.
Yeah.
But once it's set, then
See, this is the year for you to do it. I don't know when you get it approved, but this is the year for you to do it. The year that's between the renewal years. Because you potentially have more time to get it all went through. Because you've got 1,140 or whatever the magic number is right now, you got to touch every one of them
Yeah, I know.
to see what slot they fit in, whether it's even, odd, you know, whatever. And then see, when the system starts, you'll have to change, you know, there'll be some extra and so forth in the system.
expert witness, that's right.
We've asked you for the hot seat. See, you thought you was gonna get away without having to perform today, didn't you?
I can't stop a second.
Yes.
What can I do for you?
We've asked you to come see us, John, to enlighten us on the procedure that your renewals, how that actually works. We know your rule says that they renew every 2 years after they become licensed.
Right.
Okay, so just, I guess the question posed is, if I pass the engineering exam, heaven forbid, today being August,
Right.
okay, between now and the end of the 2-year window, what would you send me? Would you send me an invoice that says, hey, you're now licensed in the state of Tennessee as a professional engineer, and you owe X amount of dollars for the next 2 years that you're going to be licensed?
No, I mean, we tell them in the approval letter that they renew 2 years from their, original date of licensure. It's actually the end of the month, their original date of licensure. And so we send them a renewal notice. In this scenario, it would be in August of 2014.
Okay.
Actually, they would get their notice about 2 months prior to their expiration date to give them adequate notice.
But when you give them their initial license, what do you charge?
That'd be $140 every 2 years. Yeah, because they renew 2 years.
Right.
They pay a $140 registration fee. That may have been what you were asking about.
Okay.
Yeah, for their first 2 years of registration after
Maybe
they're
that's what
approved.
y'all start doing.
Right. And
So
then they
they are
renew.
paying a fee though to practice, not
Right.
just for their slip, but they are paying a registration fee for the first 2 years.
Yes, they do. Yeah.
There you go.
Maybe we ought to do that.
See, we have in our statute that says certificate of registration. So, and that's what normally is charged when an individual passes a survey exam. And that may cover, could cover 6 months, could cover 18, up to 18 months because of the way we're currently renewed.
Right.
Y'all don't do a loss certificate,
Yeah, we do.
do you? You charge for it.
No, we don't charge for the original. If they want a duplicate, then we charge. Right.
So could we charge
So you use that fee, that initial fee, $140, to get them to their next renewal.
Right.
And then what you're also
So they're
doing
paying the
after
first
that.
renewal fee up front.
Yeah, then they get their renewal notice and they pay the $140 every
Okay,
2
so
years.
140 is your 2-year renewal.
Right.
Okay.
So they are in fact paying their full 2-year renewal
Yeah, they do.
up front, yes. That was the main question.
Okay.
That was the main question. You passed the test, congratulations.
Yeah, we notify them they've passed and tell them they owe them $140, and once they pay that, then they're actually licensed and we send out the certificate.
Yeah.
There we go.
So we need to modify that. When we're done.
Is that, and I'm just asking this for my benefit, is that in your rules?
It's in our rules. Yeah.
The RT? Other than just the renewal fee and registration fee?
So is that how
So
we
is it need to
consider,
be in our rules?
if we got this legislation changed, is that how we think of doing it? Duplicate their statute or do it like Kentucky does it?
I'd like to do it alphabetical. It's just a sort of a personal preference for me. Reason being is, we're just trying to get some logistics as to how we might want to approach this. Because what we're seeing is, historically, most of the licensees are occurring in June and January. So it's going to be a 2-month situation that she's still going to be bombarded.
Because that's when you get exam results.
Right.
So, yeah.
Right.
That's the way it is for us, too.
Whereas what we were just, I was suggesting, in Kentucky, they just divide it like A to L and M to Z, and the first group goes on an even year, and the next group goes on an odd year.
And that's why I think
At the end of the year.
Do it at the end of the year.
Because what we're trying to do is, we have this revenue, huge revenue, and then
Right.
shortfall. And it's like a roller coaster, back and forth. And we're trying to eliminate that and get it to where it's more level to where we can really monitor if we're having any issues that we might need to increase the registrar's fees or whatever it may be.
I believe the accountancy board does their renewals that way, alphabetically.
Okay.
Not 100% positive. I could ask Mark Crawford, their director, come talk to you if he's in there.
Well, that'd be fine. Like I say, we like
I
this.
think they renew that way. It's alphabetical at the end of each year. It's the exact scenario that you presented there.
Well, it's very important. It's important to us that we try to emulate somebody.
Right.
Because in that way, when it goes up there for somebody to look at it, it's just like, well, nobody does this, you know. So we want to emulate somebody and say, well, this group does it, so it should be okay.
Right.
You know.
Right now, everybody expires.
Okay, if we do
At the
this
same time.
alphabetical audience,
Yeah.
if somebody gets their license in 2012, we charge them $208, can we charge them $208 like they do?
You're going to have some double feed individuals
And then 14?
until you get it into the first full cycle. Okay? until you get to the first full cycle, you'll have some individuals that will pay more than others. Till you get that first full cycle. So you don't have to give everybody, everybody's got to do their cycle one time so that everybody's on an even footing, no matter what part of the alphabet that they're in.
Right. So if they expire in 2013, because the law's not going to pass, it's not going to pass the next year. You're down to 6.
It'll be a year.
Yeah, but in other words, for example, if M through Z expired in 2013, everybody expired in 2013, and M through Z were odd, then when all of those folks paid, they would be on the next cycle for 15. Okay?
Right.
But when the people pay that are A through L at the end of 13, they would only pay 1 year. They would only pay 1 year. Okay? And then in 16, they'd be on the cycle.
That's right.
So does RBS calculate all
I think when we instituted it, we were on RBS. I think we started it in like 97 or something, I think, 95. And I believe, yeah, they set up RBS to prorate renewal fees automatically. That's the thing.
Yeah, 97, John.
97,
On that
okay.
particular one. But yeah, you're going to have a few odd situations until everybody hits a cycle. And then once the existing group hits a cycle, it's going to be that way now.
So do you want to talk to our accountancy director?
Well, I just like to get a copy of how theirs is worded. I think that'd be as important as anything.
Let's see what their statute says.
One other thing too is a new licensee that gets his license in June, but he would renew then in December, he'd have 6 months to pay for instead of a year.
Yeah.
So,
eyes are calculating over.
do what?
My eyes are calculating over, aren't they?
I said, well, mine too.
So that you pay.
Well, we're going to miss it.
That's right. They 70, I guess.
Yeah.
It's 280 or.
And whatever, if a year's registration was, well, what is ours right now? Not 240? Not 140. So a 1 year registration would be 70. Obviously, if he's licensed in June.
No, our 2 years is
2 years is
280, all right, 280, so, then he would have 6 months.
Right.
I said,
To pay 70.
Okay.
That's not a difficult thing, I
No.
don't think that.
It's just going to be a matter of getting it set up. The two hard parts is setting it up and then getting to the first full cycle. That's the two hard parts.
Yeah.
Then after that, you're off and running.
That would, of course, that cuts your load in half each year, but you have to do it every year instead of every 2 years.
Yeah, you would have
Yeah.
a more consistent workload relative to
Yeah.
renewals and everything, as opposed to having to try to be bombarded and get everything done in December.
yeah.
Other than the new licensees that come in.
Right.
You'll have those that still. Anyway.
Like I say, we're just in a changing environment, and that's one of the changes that we'd like to see.
Accountancy is similar. You renewed for periods of no more than 2 years. Required to renew a certificate of registration by any renewal dates may be set by the board at its discretion. The renewal process established by the board may include procedures for odd-numbered certificates and registrations to be renewed within 2 years from the date of issuance, and odd-numbered years, and the same thing for even-numbered years. That's all theirs says. Theirs is just sort of more expanded. It doesn't even say they have to do it, it just says may include procedures, it's not mandatory. So it's just the same statute with the suggestion that you can do it this way is more or less what it is. And whatever they ended up doing, I guess, is in the rules.
And now that I think more about it, my wife used to work for the accountancy board, so I have some their rules. She works for NASDA now, which is their accountancy organization. But I believe there's a setup where if their license number ends on an even number, they renew maybe during even years,
Yeah.
and if it's an odd number, I think that's how they do it.
No,
And that ensures that the population's more evenly divided. I think that if you do it alphabetically, because alphabetically, of course,
You have a whole lot of people.
you got like a lot of people's
S.
names starts with S. That's the letter I was thinking of.
Nobody with Q or Z.
Yeah, so it's going to be
Or X.
uneven. So it might be better to do it
Most of them
numerically.
will be in the-
Let me ask you this question while we're talking to you, John. Do you all assign a number that stays with every applicant?
Yeah, we do. You know, in RBS, it
Yeah,
assigns
so
a file number.
See, I really don't like that, but that's.
No, I don't either. I would rather our numbers be issued sequentially when they're approved for registration,
Right.
and have the license number separate from the internal file number.
Right.
But I don't think we can do that with
No,
RBS.
no, I've asked that question before. I just
Yeah.
was curious if y'all had to do it the same way, because,
Yeah.
you know, John Doe applies to take the test, he actually gets his license number
He does.
right then and there,
Right.
you know, and then he never takes the test, because that license number is never used.
It's tied up.
That license
Yeah.
number's tied up in now.
Right.
So anyway, I just didn't like that. That's not your all's business.
But that's something to think of when they're developing the new licensing system, because that's underway now. We could maybe request that we have the ability to issue license numbers sequentially. I don't know how they'll want to set it up. So maybe from this point forward,
Yeah,
at
this
least,
point
maybe we
forward,
could
yeah.
do it that
Right.
way. But right now, we can't. And it's odd, especially for us, because we may have somebody, I'm sure for you too, this occurs, they may sit for the exam, you know, for several years before they pass it.
Right.
And they're issued this low number from several years
Right.
ago when it was
Right.
assigned. And then somebody else that passes that same administration has a much higher number. So
Right.
it's really odd. And it throws people off too, because they tend to think if you've got a lower number,
you've been at it
you've been
long.
licensed for a long
Right.
time, when in fact, maybe not. So it's interesting.
Yeah, because I was just in the complaint report, I was using the numbers as sort of an indicator of how long we've been practicing.
Yeah. Yeah, you can't always do that, unfortunately.
I really wasn't aware that that's the way it worked. I thought you had to meet all requirements to do this.
That's what I.
Yeah.
Yeah, that's the way it was before RBS, I think. At least years ago it was. The way we did it. I don't know about y'all.
Well, that's, you know, when I was talking to you that day about how people get, how the numbers were and so forth, you know, it was always, in my vernacular, that, you know, 1 to 500 was grandfathered in the beginning, and then 500 to 1,000 took the exam, well, 500 to 1,100 took the exam, and then we grandfathered engineers in from 1,100 to 1,500. You know, and then we went back to taking the exam again as far as licensees. And then we hit 2000 and everything, all the rules went away because RBS or whatever the system's called came in, and now you've got all kinds of holes in it.
Yeah, we used to give them numbers by hand. The guys used to keep a logbook of all the numbers and names.
Yeah, we've got one of those too.
Well,
All handwritten.
yeah.
John, thank you very much for your time.
You're welcome. Anytime.
Your information is always valuable. Well, I'd certainly like to start the process, whatever it takes, Rob, to, you know, if you need a vote from us or whatever it is to start the process on trying to get to some staggered renewals, whatever system we end up doing it. And also out of our discussion, Donna, we need to really consider about what we're doing once John or Jane gets licensed to get them to the current renewal cycle that we're in.
I've already filed that legislative request.
Okay, good.
Once it's approved by the administration, then we can write it.
Okay.
The request is just, you know, we want this legislation changed for this reason. But you don't have to include the language.
Okay.
Once they say, okay, we'll carry this bill, we can write it the way we want. So if y'all want to cogitate about that, when's our next meeting? October?
So, yeah.
Session starts in January.
So at the earliest, it would be February before we would know if they have any notion of including that.
Well, there's other ways of finding out if they've decided to include it. TAPS will probably know.
Okay.
We're gonna have to get somebody to sponsor the deal. But hopefully this year, because it's not the first time we've asked for this.
Right.
Or any of these other things either.
Ooh, and that's supposed to be a 2-year rule. Just about.
The 10-year thing and the staggered renewals. The two
Staggered
things.
renewals of the things that that's
Well, while we're talking about legislative issues, let's go ahead and let's bring that 10-year thing in.
Okay.
Let's go ahead and talk about it just a little bit if we can. Basically, I don't think that the 10-year rule was ever intended to remain and stay in effect after the BS degree went in after 10 years after that point in time.
I think it was there for grandfathers.
So, you know, the issue that I've got about it, it says that it's such person that has practiced for not less than 10 years. So, I feel like that when July 1st of 2003 came along, that 10-year rule applied, and after that point in time, it didn't apply. Now, I may misread that, but that's kind of my take on it, and I think that our board has incorrectly applied that rule to applications that we've been receiving, both in-state and out-of-state.
I don't think this law is necessary as far as comity or reciprocity, because for us to accept a license from another state, it has to be at least meet our minimum requirements. So it doesn't serve any purpose for that. And I'm sure it was intended to let people that were already surveying when this whole scheme came into existence to be able to get a license without having to, you're 60 years old, you've been doing it for a while, from having to go back to school and get your degree and all that. You would keep doing what you've already been doing. That's what I think that was for. But we're not going to have anybody like that now.
I sat on a committee with task when this was done, and the intent was that as soon as we could get the 4-year degree, which we did, at that time it was just 6 years experience. That's all that was required in the position of responsible charge. And at the end of the 6-year period, after the BS degree law took effect, the 6-year experience program was to end. And at the end of that period, there was a rush of people that made applications to take the exam.
I think we had like 150 people.
Yeah,
one time.
right.
And that was supposed to have ended at that point. What made it go to 10 years, I don't know, but the board took some action to go beyond that and to say, all right, well, we're going to extend this out to 10 years rather than, and I thought at the end of the 10 years it was supposed to have ended, but it never did. And I'm like, Tim, I think that this has been misapplied. I think the intent was that this was not to go on forever. It was intended, okay, we're going to let we'll give you a 4-year extension. And these guys that haven't gotten their ticket, if they want to do so, okay, the time it would take you to get a degree is 4 years, so they added 4 years to the 6 already there. And say, all right, you can do that or else. But it has continued on, and I think we have misapplied it.
See, A&E had a statute that allowed people that had a master's degree to apply for the exam. And theirs was passed with this language at the top, effective January 1, 2008 through June 30, 2012. It expired all by itself. I guess that's probably
We should have
in
done that.
hindsight.
But
Really
that
should-
should- In hindsight, it's 2020 in this case, but it should have been done that way.
just
And I thought that it had been, because I thought that was the intent from the committee at TAPS, that as we presented this, that that's what was going to happen. Whenever our 4-year degree program took effect, then from that point, for 6 years, you could continue to apply for your licensure on the apprentice program. But at the end of that period, the date that the 4-year degree took effect, that 6-year experience program was to have ended. And sorry that it didn't have a date in there, we probably should have. So, but I would like to see that this thing either be applied correctly, or we would say, all right, the program
probably just needs to be taken away.
probably does.
See, the issue I have, it says has practice surveying. And then you go over and determine what the practice of surveying is, and it's the definition of a surveyor.
That's what I think Nate's going through. How do you practice for 10 years without a license?
Without a license,
Right.
that's exactly it.
If you practice for 9 years and 11 months, then we can get you for unlicensed practice. If
That's
you
right.
practice for 10 years, you get a license.
Get a license, that's right.
So it really doesn't make a lot of
How,
sense.
the $4 question, though, then, Rob, how do we deal with this? In other words, we're fixing to sit down here and review applications. Do we have the ability to deal with it with these applications?
The thing that really saves it here, any person who submits evidence satisfactory to the board that the person has practiced surveying for no less than 10 years. That means you have to accept whatever evidence they give you. And the way the law is now, there's no such thing. They can't give you evidence satisfactory that they've been practicing because they can't practice without a license.
That answers my question.
But at the same token, if we in fact have misapplied the rule, and I think we have, are we not opening somewhat of a Pandora's box when we start going through those applications and we turn them down because they're planning on a 10-year rule?
No, they have to provide you some evidence that's satisfactory. If your evidence is not satisfactory, then even though it's wrong.
Because I mean, the thing that we're going to have to do, not only for applications, but for continuing application and everything across the board, is no matter what state that you're involved in, whether it's Tennessee or California, we're going to have to go the same way with everything.
Well, I mean, I don't know how they can comply with this. Suppose they give you evidence satisfactory that they've been practicing in another state for 10 years. Well, they have a license there.
Right.
And that's just acceptable under reciprocity, which is in your Green Act statute. So we don't need this 10 years. We don't need it. We're already covered in other parts of our law. And I don't see how they're ever going to satisfy satisfactory evidence to you, the panel. They've been practicing for 10 years. Because it's a virtual impossibility. They're going to give you evidence of 10 years of unlicensed conduct, to which your response is to open a complaint. If you look at it from that viewpoint, what would you consider satisfactory evidence of 10 years of practice? Because as you said, we define what practice is.
The definition of practice and survey is a licensed survey.
You have to follow, if it says practice, then you have to go back to your definition and follow that. Comments. Chairman looks like he's thinking.
Well, the only thing I'm thinking about is every action has a reaction. And I'm not saying that we should soften the blow any whatsoever. I'm just simply saying that we do need to understand that if we do implement that in the strictest sense, which is what we should do, and what you've seen me do in particular with everything else, and that's what I want to do, is go exactly what we're supposed to do. So if there is no question, then we're probably going to get some heat on that. So I just want us all to be aware that, you know, if it comes, we got to deal with it.
I
think that's
agree.
fair.
I
think
agree
that's
with
fair.
you. I think we ought to apply it in the strictest sense. And as much as, you know, I understand the plight of some of those guys that they're turning their work in and what have you, but by the same token, I think that says, hey, this is practicing surveying. If a guy is licensed in another state and he got his license by the apprentice program, but he's been practicing for 10 years in that state and does not have a degree, but he has a license, he has been practicing for 10 years.
He's been using a stamp, but he's been in responsible charge.
There you go.
See, now that's another issue that I have. We no longer use responsible charge.
For
We use progressive experience. I'm totally disdain that. Progressive experience means you show up on day one in this 2-year window and you don't even know what a stake is. And at the end of 2 years, you can now carry the instrument on your shoulder. That's progressive. You have progressed. There's no question about that. Even though you've not progressed to the level you need to be, you have progressed. I've never liked that language.
well, it needs to be responsible charge.
And see, it was.
It used to be responsible charge.
It was always before until it hit here. And that's what gets us in trouble.
I'm not sure why it wound up that way.
Maybe.
It happened before you got here.
But anyway, I think you've given us the answer for the 10-year rule.
Let me ask you a question. When these people call in and they're applying for the 10-year rule, what do I tell them?
They can't.
6218-101B, it's unlawful for any person to practice or offer to practice surveying unless that person's been duly registered or exempted.
So if he's had a license for 10 years,
6218-102, practice of land
The
surveying.
gap in this, Donna, is this comes over harsher in state than it does out of state, because an out-of-state individual should have a license. And if that out-of-state individual has had a license and they don't have a degree, and they have practiced for 10 years, then this board, as I understand, I don't put words in nobody's mouth, but this board would review their applications to see if their application is adequate for us to allow them to take our exam. Did I say that fair?
I think that's right.
That's what our statute says.
Yeah.
An applicant may, in the absence of disqualifying evidence, be deemed by the board to be fully qualified to practice if that applicant holds an unexpired certificate of registration, DC, or any of our other states.
You see where we're coming from now? In-state, no, period. Zero. Out of state, if they have a license without a degree and 10 years experience, we're going to consider their application.
Of course, then it says in which the examination requirements for the registration of land surveyors are of the standard satisfactory to the board.
And see, that will never be because of having a state-specific exam. I don't know of a state that really does reciprocity at all, because they all have state-specific exams, and they want you to know about the history of their state and their little nuances and rules and so forth. And you should, if you're going to practice it. You should know those.
States got a different topography.
Right. Everything's a little different.
so from this day forward, no in-state 10 year.
They can't qualify for it. If you go back to 101 and 102, which defines, first, you can't practice without a license. Second, it tells you what practice is.
Right.
Well,
And
then
they
they're
can't
going to say,
be-
the law says 62, 109.
The board interprets its own law, and what they think it says is irrelevant.
This is not going to be an easy transition. We've just now put on a real set of bridges, so we're going to have to go forward. You agree with that?
I agree.
It's to safeguard the health, safety.
And if anybody calls, give them Sue's number.
Right.
And she'll sell them that flag.
Cell phone number.
She'll sell them that flag.
Well, in order to safeguard the health, safety, and welfare of the people of the state, which is what we're supposed to do. We're not here to help people get a license. in the strictest sense. We're here to make sure the people that do get a license know what they're doing.
Right. Okay. The next item on the agenda is discuss fee changes for NCAAS exams and applications. I'm not sure we're 100% ready for that, Donna. Can you, but we'll discuss it if the board wants to, but could you do a little investigation and give us the numbers as far as what you asked the applicant to pay, and in other words, just that whole fee structure. In other words, if I was for this one exam, in other words, if I was applying, what would I pay to do my application, to take my test, and then what would the board office pay NCAAS for the exam package, the scoring of the exam, and also the administering of the exam. At this point in time, we have to consider Peter in the equation because he has to go administer it.
Yeah, but his aren't broken down by exam.
Well, I think you could take the number of exams. In other words, if he charged X amount of dollars and he administered 62 exams, just divide it. That's close enough.
Do you mean divide it by 3 or divide it by the number of FS exam takers?
No, take the total number of FS, total number of PS, and the total number of TS, because that's the actual total number of exams he administers in a setting.
Right.
Okay.
That's what I'm saying.
And then divide that number into whatever his bill is.
So like if we have 55 here.
Yeah.
Divide 55 by his bill?
Yeah.
Or divide, so we have 30 FS.
Yeah.
You want me to just divide 30?
Well, you could. I mean, you could
See how many FS we had.
What I'm looking at is a per exam situation. So, if you just took the total number of exams he administered and divided into his amount, his bill, that'll give us a per exam fee. And just keep it simple that way.
Okay.
Just simple arithmetic.
Okay.
Yeah, that'd be the simplest.
And then that way we can look at that and at the next meeting, because we know it's going to take a while to get this through. At the next meeting, then we can make a decision about that, because the only fees we can charge are the fees that's in our law.
Right.
So if we modify those, we've got to send it up there and they got to change it. And if we need to add any or whatever, but we'll also be able to predict what it needs to be if we have all those figures. So if you'll do that, I'll make a note here that
And you want it for the next meeting?
yes, you'll get that for us for the next meeting. And that way we can all look at it and say, okay, it costs this much. Tell you what, let's do. Can we go ahead and sign the law certificates on it and get those out of the way?
These are LSITs right here.
I'm not sure. I'm not sure. It says sure on the envelope.
Oh. These are all the certificates.
What we're doing, I just measured the stamp. It's about 1.95 inches or 1.9 inches, something like that, across the face of the stamp itself. I think it's right at 2 inches.
So instinct
It's roughly a 2-inch stamp.
is probably about the same for a numbers.
Yeah.
Yeah, very
Engineering
simple.
stamp.
So,
There's probably some standard off the supply chain, no matter what the stamp says. So it's a good choice.
so we need to do those in black.
You got black pen?
Or that's blue.
I got black.
But I may have black. I think this is black. Yeah, it's black.
Sue signed it on the vice chairman line.
So it's okay.
Sign under chairman.
I'll be there.
That's fine. I'll sign on the back, I think.
You're vice chairman when it passes, so
Yeah.
your son's vice chairman.
I did.
Okay,
Yeah,
good.
she is,
good.
I'm
Yeah,
trying,
she is.
I'm making sure I stay on board
Okay,
with that.
that's good. I just double checking.
What about David's signature?
Send it to them by mail, sign them.
You'll print your name.
So why they'll read it.
Lines, a few lumps that make your work.
So why they read it. Awful lot of these, don't you double them up?
No.
Eh,
I think I got all the blank ones out
You just gotta send them a notice now, tell them how much money they actually have. Now, she didn't mention
there. Yeah,
this
that's
on
it.
that
That's a, I didn't
one.
get
That's
the
a folder.
blank ones out.
I was gonna say,
That's
it's tax
fine.
much
That's fine.
big.
Oh my God, these others fall over.
Can you just give me an envelope for the street? I'll take his home.
Yeah. Don't, you know, keep them around.
Leave my fingers around. Yours is not doing much better than skipping. I think I've got one here.
Here, here.
Guy here is from the last.
You know him?
I didn't know he had a surveyor when you were in class.
I guess you do now.
Yeah, I'm guessing, you're right.
Yeah, buddy.
Oh,
Let me 10-year rule application.
We're gonna do fine all that.
Yeah, what do you
We're gonna
think?
turn, I said we're gonna turn all them down.
Yeah, them be the best pictures you like.
Right, look at them. Just get them out, just send all them 10-year experience, they cannot take the test.
If they're in state, no. No way.
Don't even say, I cut out about 50 of them.
Five.
You smelling a roses here, I can see it.
They're gonna be all disappointed. But maybe you ought to let them make the I'll make the motion, they get to take the bills and we'll start that way they can do that. You want a second, Chairman?
I was the chairman, I said,
Okay.
chairman don't vote.
They don't.
This is the only board of this type that I've ever been on. The chairman does not have any ability to be involved in the motions whatsoever, other than just conduct the meeting.
What is the time for when? They vote for it?
Yes, break the time.
Yeah. Okay, right. You vote in, I mean,
Probably would have to, yeah, probably would have to.
it's minutes. The last page is minutes.
There's certain things we don't do everything do.
We just had you.
You want me to stamp this too?
Yeah, we'll fill in the rest of the blanks on the top.
Yeah, of course.
I gave it Northcutt. And me and Sue will be witnesses.
Thank you.
Yeah, that was good.
All right. We've got that little chore out of the way. It's always a good thing. Okay. I guess the next thing that's on our agenda is to discuss application and reference form modifications. I think everybody's got those on their little, whatever this thing is, iPad.
These are just a draft, so anything you're gonna change, you can change up here. And I think I followed.
I think it's a nice looking format. Certainly asking what we wanted to ask. And again, we're speaking to us being professional land surveyors. I like that. I think we need to continue that pace.
So do I.
We keep preaching about it in all of our technical society meetings and everything, but it doesn't seem like everything goes that way, so maybe now we can get it going that way.
No, I just now noticed I don't replace looking for a picture.
That's very important. Sue cannot approve an application without a picture.
So, do you want me to put a place on here for a picture, or do you need a picture, or?
I think it needs a picture, whether we have a place on here for it or not.
But Donna, what you could do is lower the, move the state of Tennessee part over under the seal, and lower that side there, and you put the picture on the other side, in like line 6 through 8 or something. There's plenty enough room to put on the next page. At the top. Just slide that down. I think you'd have enough room for that. Second page there, the word school got whacked off there. Chul, on line 17 there, the Chul diploma. I'm not sure what kind that is. All right.
Can there be a place where they're asking if you're qualifying on category A, B, or who knows to me?
Well, if there's A, B, or C, yeah, I did do that, but I can put it on here.
Well, I can tell you.
They put on there.
Yeah. Yeah, this is just a draft because then we even speak to it there, and I'm considering whether or not. Well, I guess we need to still speak to the GED on there. I mean, a person could have a GED and a college degree, but it says if you have a college degree, you don't have to submit those. just trying to be consistent with what we just discussed.
The only thing that's on there, Robert, remember when you sent us the email about citizenship and all the crew kid home? Does this need to go on there too?
Proof of citizenship.
Yeah, you know, what you get, driver's license, so.
I think we're still discussing that.
Okay. So I don't need to put it on there right now?
Because that's a new statute.
I believe in question 12, after licensure in, it should say any, I think. Licensure in
Yes.
any state or territory. And on question 14, I'm thinking it should be expanded to say, do you have any charges pending against you by another state board? Which that's consistent with what, if you said yes to that, what you'd have to answer when you got back to the actual question.
What was it on 12 that you had said? On
The word "and" should
Must
be
be
"any."
any. Now, I have a question on modification, the experience record.
Okay, go ahead.
Where it says engagement. Now, these people are not. Engagement. What do you mean by engagement?
Well, it tells you right here, it says list engagements in chronological order.
Should I leave it like that, or should I put a job number or position number?
No, I think you just leave it like that.
Okay.
If a person has a college degree, they ought to be able to read the instructions and understand how to fill it out. If they can't, we're all in trouble.
Too smart.
Yeah, I understand.
And y'all may not want to see pages for experience background, but I didn't know really.
What's that?
Pages, number of pages for experience.
That's fine.
When you put 3 in there,
Is that what I put?
Yeah, there's 3.
3?
And then if they need more, they can make copies.
Put 1 in there if they need more. They can put
Right.
5.
Yeah, 1 would be fine.
But you're going to do the same thing.
And you're going to have this on the internet, so they can pull it right off there anyway, so they can print as many as they wanted to. Let's go to the page that talks about verification of land surveying experience. Experience. I can certainly understand where it says your PLS supervisor or associate must have been licensed prior to the time being verified. That's a good thing. I like that. But when we go down to the reference part, it says that you may use PLS supervisors.
Yeah, because I just copied this off of that.
Yeah.
So, just however y'all want it, just tell me how I'll do it.
I just think we need to strike that. That was the only comment I had about it, because it says in the sentence before, you must use licensed professional surveyors.
Okay.
But,
So take the whole thing out right there. You may use PLS.
yeah, that you may use, I'd just like to strike that. Just strike that, good. And we do not have yet the, here it is, the verification form. We had a reference form, but we didn't have a verification form. And I would really like to keep those separate, because the one we have right now, it really is somewhat convoluted,
The experience.
because they're verifying experience and they're trying to reference at the same time. If they have to do it twice, I mean, I really wish they had separate ones. I know, and then I know this is one thing that David has spoke on many times from his area, that it's hard to get just 3 to get your application. So I don't want to penalize anybody because of that. But same token, I would rather ask the surveyor to fill out 2 forms to send in for the applicant, because I don't see that as a grave injustice to the surveyor. Because we're already asking him to certify that the young person drew the plat, did the calculations and everything, and the description. You know, I guess where I'm coming from, if a person is in my employ and they're applying to take the license examination or any part thereof, then I should know about it, and I should be able to help them with that process so that, you know, they basically get their application right type thing. Not do it for them, but basically help them, because that's part of the learning experience also.
I'll try to have to draft that one, the experience verification form for next meeting.
Okay. Well, we can do a few of these tweaks on this and then have it look at it again. That's the main thing, was just to try to get it.
Right.
And because I think this is going to look much more professional. Because, you know, our forms, gosh, they've been very little done to them, and who knows when.
The one we've got now, not been changed since probably 2001 or 2 or something. Nothing was done.
Does the website have the ability for the applicant to fill this out? Okay, so they can fill it out right there. They can't submit it, but they can fill it out and print it. Okay, good.
Fill it out and print it.
Good. Okay, good. Okay, on the reference form, I think that we missed a heading down there where you've got all the check mark areas, because you have 4 categories. You've got above average, average, below average, and dissatisfactory or unsatisfactory. But we didn't get those headings over the little topics.
Well,
Not a big deal.
I'll fix it.
Now,
I mean, no.
at the top, under reference form, it says 2 of your 3 references must be professional land surveyors and have knowledge of your experience. It should be all.
Do you want all 3 of them?
Because on the form we just looked at,
All right.
the form we just looked at, that had that blank on references, it says all of your references must be licensed professional surveyors. So I'm just trying to be consistent.
Okay.
So that should be all. And then on the next page, do we want to use expiry instead of expiration?
I don't know. That's up to y'all. How y'all want to do it?
I mean, it's okay, but expiration looks a little bit professional, I guess. I'd rather use expiration. And then, instead of saying please, affixed seal.
I'm gonna take please out.
I had seal must be affixed with signature, or whatever.
Company signature.
Just strike please, capitalize A and affix seal.
Yeah. That's fine. Anyway, so they gotta get the point, because we have so many that won't even do that.
And I've sent some of these back.
Good, that's good. But overall, I think it looks real good now. You're doing a good job on it. And tweak a few things and get us that verification form, and maybe the next time we can adopt this or something. Start using it. Now, going back to one thing, on the front page, it says a non-refundable $200 application fee. Now, is that not only applicable to the individual that wants to take the entire exam? It's not applicable to the FS exam? Or do you still have a separate application for the FS?
We'll still have separate.
Okay, that's fine. That's fine, as long as we have it separate for them, because I think theirs is for like $25
Yeah,
or something.
yeah.
Okay, real good. Anybody else have anything on the applications and the reference forms? Okay, the next thing on our agenda is to discuss continuing education rule changes. I would like to defer that into the morning, if that's all right with you all, and see if we can spend some time on these applications this afternoon and kind of see how far along we get. And then we include applications in the morning or whatever we need to do from there, if that's all right, y'all. Rob, you need anything else from us?
No, I'm gonna go up and start trying to get that notice together so we can get
Okay.
that out of here and we can start.
I was gonna ask you if you want me to take it back, send it back to you or whatever, but it'll be Monday the earliest I can get it to you.
Well, I'll just use the copy I already have.
Okay.
The copy that was loaded on the here was on my hard.
Okay. Like I say, you know, in that one section, there was that one paragraph 5 that's left out. And,
Yeah, but I think we're gonna delete it anyway, won't we?
No, I know we're going to delete 5, I don't think. I don't believe.
Let's see. Let's make sure it's right.
And then we got to get the picture of the stamp in there.
Yeah, I don't know how that works. Getting the little picture of the stamp in there. I have to ask somebody that knows more about computers than I do. How they
Number
import
5
it.
was in rule number 5, conflicts of interest. It says the registrant shall not attempt to supplant another land surveyor in a particular employment after becoming aware that the other has been selected for that employment.
I've got my 5 says registrant shall not realize.
Right, that's what I'm saying. It's, for some reason, it's not on yours. But we had that one on there before.
Yeah, if you can just email me that one.
Here. Take that right there.
Or I'll just type it in.
You can type that in. Because then I won't have to change it, I'll give you that.
I'll put that 5 in there and then.
And put that 5 in there, will be business, that and stamp will be business. Make sure you change registered on that stamp to professional.
Yeah.
That way we'll then begin to get very consistent throughout. Because see, that's what NCWS recognizes us as professional land surveyors. And more states are doing the same thing. Most states register cattle to the surveyors.
You want to change registered to professional?
Yes.
On the seal.
On the seal.
I have a question, just for information. When will we require surveyors to have their stamp with professional land register?
As soon as the rules are effective. We'll tell them whenever we file it, 90 days from this day, this is effective 3 months, that's plenty of time to go to the office.
That's fine.
Good. Still doing
And
very
the old,
well.
Dylan won't have to have a new seal with it, unless they just want to have one made.
Yeah, we're,
You will?
Yeah, we'll
sure
We're
we're,
not there, yeah.
just
So we're basically.
yeah, we're moving business, that's right. Governor likes that, we're having a conference. I was trying to remember which one Kentucky changed.
One is Sue, the first.
Not Sue, first name.
44 cents, or you know, it is 45, whatever it is now. But Kentucky changed theirs, I think it was theirs several years ago. They went and added professional land surveyor to theirs. And theirs is actually a stamp, it's a little square stamp, looks like a postage stamp.
Really?
Yep. And I had to go get a new stamp.
I've seen some strange shapes. Ours should just be shaped like Tennessee. You can just write it linear. We have a simple shape state. Not as simple as Colorado, but pretty simple.
Okay.
What does Colorado have? Land surveyor.
Well, if theirs is in the shape of their state, it'd just be a box.
Yeah.
Okay, well, let's, if it's all right with everybody, let's take us a 5-minute break here. And I'll turn the TV off, and when we come back, we'll do the applications and we'll have to go to. That works for Miss Sue.
I'm gonna go backstage.